Item number 1 to be spoken.
Maid, please, your lordship. I appear for
Yes,
that.
there is some discrepancies. I mean, in the order of the trial court.
Please, lordship.
See, all throughout your case is registered as Naharlagun PS case.
Right, lordship.
Naharlagun PS case number 74 or something.
Right.
2024.
Right, lordship.
But in the order dated 30/12/2024, if you can have a look.
Yes, lordship.
There the case is shown as Papu Hills PS case number.
I think, lordship, this is clerical error, lordship.
So this clerical error we cannot take into account like that. So you'll have to get it corrected.
Okay.
Yeah, because Papu Hills is a different police station altogether.
Okay, lordship.
So this has to be corrected. This should have been seen by you all. I mean, probably it has been overlooked.
Okay.
Probably it has been overlooked, but this has to be corrected now.
Okay. Lordship, I have sent the charge sheet on record. Kindly see the charge
No,
sheet.
correct. So then everything is fine, but this order sheet with this error on the face of it, it cannot be taken into account.
But
So this
okay,
has to,
lordship.
I mean, he'll have to approach this court. Chief Judicial Magistrate Court and get it corrected. Then he'll have to bring that on by way of an additional affidavit or whatever.
Okay. But lordship, everything is mentioned in charge sheet. If we
No, I understand that. But like this, I mean, this has to be corrected, isn't it? It can't be like this. There's a different police station case number referred in the case where the order was passed.
Okay.
So how it can be taken into consideration just like that with the error? So that has to be corrected there only. It cannot be corrected in the High Court.
Okay, lordship.
So you'll have to approach. I'll release this matter from my board, and you'll have to approach the lower court, trial court, and thereafter you have to get it corrected, and the correct copy has to be brought on record.
Lordship, it will be very difficult to approach the trial court because, lordship, we are very far away from.
No, that can't be helped. That technical difficulties I understand, but on the face of this case record being wrong, I mean, I cannot pass any order on the basis of this. Yeah, I mean, without this being corrected, you have to engage somebody with a local counsel to get it corrected, because it's a typographical error. It will not take much time. It will not a review order or something like that. It's a simple typographical error. It has to be corrected, and it is brought on record.
Lordship, kindly pass the order like the correction be corrected.
No, I'll simply release this order. I mean, release this from the board. Then you can get it corrected.
Right,
Because
lordship.
there is you can file an application for get it corrected there.
Right, lordship. Right, lordship.
Okay. I take it down. I heard Mr. S. Dahiya, the learned counsel, appearing for the petitioner. Though the matter was heard finally, but during the passing of the order, there was a typographical mistake noticed in the order dated 30/12/2024, passed by the Judicial Magistrate First Class Capital Complex at UPIA. Full stop. It is seen that instead of writing Naharlagun PS case number in the order set, it has been mentioned as Papu Hills PS case number 74/2024. In view of the aforesaid, this instant petition is released from this board, and as agreed by the learned counsel appearing for the petitioner, this order has to be the error stroke mistake has to be corrected from the concerned court of Judicial Magistrate First Class Capital Complex at UPIA. After correction of the aforesaid order, the petitioner shall bring the aforesaid order on record by way of an additional affidavit before this court. Let the matter be fixed after 4 weeks. 4 weeks time.
Right, Lordship.
Let the matter be fixed for after 4 weeks for the hearing.
Right, Lordship. Obliges, Lordship.
Mr. So-and-so appears for the. So you get it corrected. It can't be helped. These are small technical errors, but like it cannot be helped. It has
Right,
to be
sir.
corrected or recorded. It has to be corrected. Otherwise, there will be a problem.
Okay, right, Lordship. Oblige, Lordship.
Item number 2,
Yes.
My lord, I have filed a civil revision petition challenging the impugned decision passed by the Association of Gambura of Nirmova Circle, my lord.
What has happened?
My lord, I have an ancestral land
Mhm.
I have inherited from my father after his demise.
Mhm.
So one day, my lord, when I visited my land, I found that someone has fallen trees and collected firewood.
Okay.
So I posted the hoarding restricting the activities on my land, my lord. Then on the next day, when I again went there, I found that the hoarding was damaged. Then again, I put it up, my lord. So after some days, I received a Parwana issued by the Association of Gambura, my lord. So it was mentioned that since the present respondent has lodged a complaint before the president of the Gambura Association, that I have put a hoarding on his land, my lord. Here, my lord, the president is the brother-in-law of this respondent, my lord. He has married the immediate sister of this respondent, my lord. So on the day of Kaba, my lord, I raised my objection that the Association of Gambura do not comes under the definition of customary code given under 2D of this Arunachal Pradesh Civil Code Act, my lord. But the Gambura Association has adamantly passed the decision by saying, my lord, that since my father and the father of respondent were good friends, so my father might have given that land to the father of my respondent, my lord. And based on that, they have passed the decision, my lord. So I requested the president of the association to furnish me a copy of the impugned decision, my lord. But the president refused and denied to give me because he said, unless I accept and sign the decision, he will not furnish me. Then I approached advocate, that was myself, my lord. This petitioner approached me and I served a notice to Gambura. Even then, Gambura denied to furnish me the copy. Then, my lord, I approached the in charge of the EAC, Extra Assistant Commissioner of Nirmova, and on his instruction, my lord, this copy of the impugned decision was given, but it was a scanned copy, my lord. He also again refused to put his signature and seal on the decision, lord, decision copy, my lord. So since by the furnishing of the period, my lord, this already appeal period before the civil judge was over, and my lord, one fact here is that the
Civil judge is already over.
Yes,
Appeal period.
yes.
You haven't filed there.
I haven't filed there because the Gambura did not furnish the copy on them. And my lord, since as per the Arunachal Pradesh Civil Court Act, Section 15, Clause 4, my lord, if any party is aggrieved by the decision of the customary court, village authority, he can approach the inter-village territorial forum, my lord. Here, my lord, this Gambura Association and the party that the
But
jury member.
next appellate court was civil court.
Yes, my lord.
But without filing it before the civil court, how can you come with the High Court?
Here, because my lord, the fact is that Section 15(4) of Arunachal Pradesh Civil Court Act says that any party aggrieved by the decision of the village authority can approach the inter-village territorial forum, my lord.
So you are saying that that is not in that is not in recognized village authority.
That is there, my lord. And now the impugned cover has been passed by the Gambura Association, which seems to be like a form of village authority, but they have assumed the character of an inter-village territorial forum. Because if a simple village authority has passed the decision, I could have appealed my case before the inter-village territorial forum. But here, my lord, this Gambura Association include the entire GB of the Nirmova Circle, my lord. So now the one appellate forum is missing here in this case, my lord. So I have.
No,
approached
but
the
what
court.
about the civil code?
Civil court, my lord? I have not approached the civil court because here, my lord.
No, whether you can directly come to the High Court without approaching that appellate court of civil court.
Yes, my appellate court was, my lord, inter-village territorial forum.
Inter-village territorial forum and,
Yes, my lord.
and any order passes by inter-village territorial forum that should go to the civil court.
Civil court. my lord.
Yes.
So here, the inter-village territorial forum, the appellate forum, my lord. But here in this present case, my lord, the inter-village territorial court has directly taken up the matter as an original court. This case would have been taken up by the customary court of S.C. Abe, where I belongs to, or of the customary court where the respondent belongs, that is of Escarte, or where the disputed land is located, my lord, that is the Talo village. So this case has been either taken up by the village authority of my village, the respondent village, or the land where this disputed land is located. So here the law has been directly breached, my lord, because section 17 of Arunachal Pradesh Civil Court Act very clearly specifies that any person who is interested in the case cannot supervise the government, my lord. So here the president, the chairman is the immediate brother-in-law of the respondent, my lord. So not in the merit only, my lord, in the term of legal provisions also, my lord, my right has been curtailed and there is procedural lapses which can be corrected by this honorable supervisory court, my lord. So I have approached before this honorable court with the civil revision petition, my lord. And my lord, during this pendency of this more than 1 month, my lord, by the strength of this impugn Kabadi decision, the respondent has started cutting and felling down all the trees located available in the disputed land, my lord.
But you have been mentioning it as a KEVA decision only.
Yes, my lord.
No? Is it a KEVA decision?
That is the problem here, my lord, because this the
So
Gambura association-
yourself you are writing this is a KEVA decision.
Yes, my lord. This Gambura's,
The Gambras Association is not a KEVA
Yes.
as per the the rules. Correct?
since because they have mentioned this as a kaba in the judgment and the summon parwana, my lord. That's why I have to mention it as a kaba, my lord. But I have raised my objection in the petition itself, myself, that is not the kaba. They are only association and union of Gamburas, my lord. They are not kaba bodies. But since they have mentioned their decision as a kaba decision, my lord, so I have to refer it as a kaba, my lord.
What is your prayer?
My prayer is that, my lord, this matter may be admitted, notice may be issued, and my lord, it is my prayer that since the disposal of the matter as an interim, my lord, this impugn decision may be stayed, my lord. Otherwise, the respondent will cut down the entire trees available on disputed land, and the purpose of approaching this honorable court will be defeated, my lord.
So where is the rule, Arunachal Pradesh rule? Where is it? Hmm. It is the Civil Codes Act.
Yes, ma'am.
Which are the sections that you, rules that you have referred to?
Section 17, ma'am.
sections. First is that wherein it is stated that Council of Gamburas is an intermittent,
Inter-village.
correct, inter-village. Where are those provisions?
Section 2D of
Section 2D of
Arunachal Pradesh Civil Court Act, my lord.
Section 2D.
Yes, my lord.
2D says customary court means courts of traditional council or authority of villages. Village indigenous in the state, whenever called, includes the court of village authority and so and so. Assam Frontier Administration of Justice Regulation.
Yes, section 5.
The first court is the customary court, right?
The customary court blaze.
Customary court is the KEBA.
Yes, my lord.
So KEBA, there is some confusion. I mean, whether it's a one village or multiple villages.
My
Is there?
lord, KEBA can be conducted by the customary court, but customary court is categorized.
Customary court.
First original court is the village authority of the immediate village, my lord.
Yes, now that is recognized under this or not, Civil Courts
Yes,
Act.
my lord.
It is recognized under section 5, no?
Yes, ma'am.
Because section 5 of this.
Yes, ma'am. Section 5(1), my lord.
Mr. Sharma, what are you giving? This is Assam Forest you are giving. Where is the,
Page number 52, my lord.
of this book?
Yes, let's say volume 1, page 52, my lord.
Page 50?
2.
Yes, page 52,
No.
section 5.
5, yeah, section 5, clause 1. The deputy commissioner shall appoint such person as he consider to be the member of a village authority for such village or villages as he may specify, and may modify or cancel any such order of appointment, and may dismiss any person so appointed.
So this is the customary court.
Yes, my lord. So here in this case, my lord, this KEBA should have been taken up by the customary court of either the village where I belong, or from the village where the respondent belongs to, or the customary court of the village where this disputed land is located. My lord. Thereafter, if I am aggrieved or the respondent is aggrieved, he will approach this inter-village forum, my lord.
Inter-village forum is called?
Inter-village forum is called Bangor level, district level, or this.
Bangor level, district level.
Yes, my lord.
Okay.
So,
And,
but
and after the Bangor level, district level only, you can come to the civil
civil
court.
court.
Civil court.
Yes. that is
Herein, I mean, they have directly gone to the Bangor level.
Yes, my
Hmm?
lord. Yes, my lord. Because here, section 15, clause 4 of Arunachal Pradesh Civil Court Act, my lord.
Section 15,
Section
yes.
15,
Appeals from or decree or order passed by, not this one,
15(4), my lord.
15(4).
Yes. Page number at 14, my lord. Arunachal Pradesh Civil Court.
Page 14?
14, my lord. Volume 16.
No, this. Arunachal Pradesh Civil Courts Act 2021, right?
Oh, now, after amendment of this, a new publication is there, my lord. With latest amendment. Page 14. In 2023, there was the amendment, my lord. So,
So an appeal from village authority, if agreed to by the parties shall before, is agreed or it should be agreed?
Yes.
By the parties?
earlier it was agreed by both the parties.
Hmm.
Now, after the amendment of 2023,
Hmm.
it has been inserted that any of the party who is aggrieved. So, an appeal from the village authority, if agreed to be the parties, to by the parties, or if the aggrieved party desire to appeal, as the case may be, shall lie before the inter-village territorial customary court or FX customary court by whatever name called, which shall settle the case as per the local traditional customary laws under the provision of Section 40 of the Assam Frontier Administration of Justice Regulation 1945, provided that an appeal against the order of the Inter-Village Territorial Court or Apex Customary Court shall lie before the Court of Civil Judge, Junior Division,
Where
What-
are you reading? I'm not getting it. Page
Section 4, page 14, my lord.
14, section?
Clause 4, my lord, at the bottom, my lord.
This is 21 only. So Arunachal Pradesh Civil Code Section 21.
Volume 16.
Is it Arunachal Pradesh Civil Code Act 2021?
Yes, my lord.
2021, which section you are referring to?
Section 15.
Section 15 is appeals, yes.
Yeah.
But out here only three
Yes,
subsections are
in the next page, my lord.
provided that.
Yes, at the bottom part is the clause 4, my lord. Second last paragraph at the bottom.
There is no clause 4 here.
14 in my lord, in page 14
Hmm.
at the second last paragraph is a clause 4, my lord.
Oh, it is not there.
देखिए,
It has only 3 clauses.
ये वो.
ये तो नहीं क्या मतलब पहले क्या तो नहीं है is different. फिर गलत तो appeals तो ठीक है सर appeals 3 लेके है ले provided but like some they have added something. This book doesn't contain that.
That might be by older publication.
Okay.
Yeah.
So your grievance is basically that if, I mean that initial courts would have been the KEBA,
Yes, my lord.
KEBA, and
Yes.
thereafter inter-village
Yes, my lord.
inter-village authority.
Yes, my lord.
And since inter-village authority has taken the matter at the first instance only,
Yes, my lord.
so you are aggrieved.
Yes, my lord.
That is only your case.
No, that is not only my case.
Hmm.
And the second is that section 17 of this Arunachal Pradesh Civil Court Act very clearly specifies
Hmm.
that any person who is interested in the issue
Hmm.
cannot supervise the KEBA, my lord. So section 14 clause 1, 2 is very clear.
Section 14,
17, my lord.
17,
Yes,
1.
1 and 2. It is
No
very clear.
judicial officer, authority, or customary court shall try a suit in which he is a party personally interested.
It is 1 and 2 is
No
So-
judicial officer or authority of customary court shall try any appeal. But is he, I mean, is he,
yes, my lord. In my petition, my lord, at para 16, I have very clearly
Hmm.
established the relationship, my lord. As my lord may please come to page number 16, my lord. My lord, page 16 here, my lord.
yes, yes.
Respondent is the son of late Gamo Jilen, my lord. So Gamo Jilen had 6 children. Late Moken Jilen, late Moto Jilen, Sri Momi Jilen, Sri Moju Jilen, that is the present respondent, and Srimati Mopak Jilen, that is the wife of this president, my lord, the chairman of this Kaba, my lord.
So, I mean, this, who is
Mopak Jilen, serial number 5.
Mopak Jilan?
Yes. She is
Mopak
the
Jilan is the wife
wife of
of this
chairman, my lord.
chairman.
Yes, president come chairman of this Kaba, my lord. So he is a directly involved and an interested person in this case. So here, my lord, my grievances is that Section 2D has been violated of Arunachal Pradesh Civil Court Act because this Gambara Association is not a customary court as per the Section D. And my lord, Section 14, which gives about the appellate forum, that is been also violated here, my lord.
14,
Section 15 clause 4
15
has
plus-
been violated because the matter should have been adjudicated by the village authority, my lord. But the appellate forum had directly taken up the matter, my lord. And this third one is, my lord, Section 17, my lord, which is clearly says that interested person cannot preside over a Kaba or an issue, my lord. And my lord can clearly see that the base of the deciding the Kaba is that since my father and his respondent father were good friends, so my father might have given the land to the father of the respondent.
Where is that? Where is that? Page 25.
25 is the translated part.
Where it has been stated?
A second paragraph. The Kaba, this Kaba body accepted that this land originally belonged to the father of the appellant, the petitioner, my lord.
No, where is that? Where is the para 2?
Para 2, my lord. As per the statement, really the land originally belonged to the late Gumyor Pal, that is the father of petitioner, my lord, as per the witnesses. Even then, there must have been a word of assurance between late Gamojilen, father of the respondent, and the late Gumyor Pal, that is the father of petitioner, to exchange the land, because since time immemorial, both families have lived together like one family. The exchange field, Dukur and Dubu had been also compensated, and the matter has been cleared. Therefore, the Lenya field shall now be given to.
No, what was this? This exchange fields, Dikir and DB
That is
had been
different.
compensated.
Yeah, that is different land. But why they mention this in the cover, I have no idea. But this is not the case. The land here in dispute is the Lenya land.
Linear land.
Yes. No, that is the only reason, my lord. That my father and his father were good friends, so my father might have given the land to the father of the respondent. Only based on that assumption, my lord, they have passed this impugned decision.
Okay, take down. Third, Mr. You are Mr.
K. Tasso, my lord.
K. Tasso.
Yes.
Mr. K. Tasso, the land counsel appearing for the petitioner. This is an application filed under Article 227 of the Constitution of India under the supervisory jurisdiction of the Honorable High Court for quashing and setting aside the impugned decision dated 7/10/2025 passed by the Gaonbura Association of Liro Mumba Circle, West Siang District, Arunachal Pradesh, without having jurisdiction and in violation of natural justice. Don't write those. I mean, you write challenging so and so till Arunachal Pradesh. You write, okay. The case of the petitioner is that a Jumeland area, namely linear Jumeland, known as linear Jumeland, is an ancestral Jumeland of the petitioner, and which he has inherited from his deceased father as per Gallo customary law and practices. However, during his visit to the Jumeland, one day he found that unknown people had cut down certain trees, bamboos, and collected firewoods from his linear land. Full stop. To stop the further activities at the linear land, on 15/6/2025, the petitioner put up a hoarding of public notice by prohibiting any kind of activities at the linear Jumeland area. Full stop. On his further visit on 25/6/2025, the petitioner again witnessed such activities of cutting trees and collection of firewoods, and also found that the public hoarding he had put in the linear land has been damaged by certain miscreants, and the same was lying on the ground. Full stop. Though the petitioner did not do anything at that point of time, after a while, on 26/9/2025, the petitioner received a parwana summon dated. When did you receive it? You haven't just mentioned the date.
It was received on the same day.
Huh?
On the same day.
On same date?
Yes.
On so and so. Parwana summon dated 26/9/2025, issued by Sri Jubin Romin, head Gaonbura HGB, President Gaonbura Association, Liromoba Circle, West Siang District, Arunachal Pradesh. It was learned by him that the respondent, that is Sri Mojur Jilen, had lodged a complaint alleging that the petitioner had put a notice in the land of the respondent, and therefore, in view of the aforesaid complaint, a Keba was fixed on 7/10/2025 at Limoroba Bango Deer (Community Hall), and therefore he was requested by the summon. He was directed in the summons to appear before the aforesaid Keba. Full stop. Next paragraph. The petitioner contended that he attended the aforesaid Keba meeting held in Limorama Bango Circle, Bango Deer, right?
Yes, ma'am.
There only.
Yeah, there.
Circle, and objected to such hearing of the matter, as he pointed out that only the village authority of a concerned village can take up the issue at the initial level, at the initial stage in terms of this,
Yes, ma'am.
in terms of
Arunachal Pradesh Civil Court.
in terms of the Arunachal Pradesh Civil Code, and the Gaonbura Association as such has no authority to conduct KEBA unless an appeal is filed against the village level KEBA, which is the preliminary court of hearing some such customary disputes. Full stop. However, the chairman of the KEBA, aforesaid KEBA, namely Jubin Romin, head Gaonbura, stroke President Gaonbura Association, Limoriba Circle, refused to entertain any such objections on the ground that they have not received any such directions or instructions from the Office of the Deputy Commissioner, West Siang District, in bracket AP, or Additional District Commissioner, Yamcha AP, in bracket AP. It was further declared by the aforesaid chairman that they, being the Gaonbura, they have lawful authority to conduct the KEBA, and thereafter proceeded to pass the order, pass their decision dated 7th October 2025, wherein they held that though the land originally belonged to late Gumiur Pale, there must have been some word of assurances between late Gemo Jilen, who is the father
Yes, father of the respondent.
Respondent, and late Gumiur Pale, the father of the petitioner, to exchange the land because since time immemorial, both the families live together like one family. In view of the aforesaid finding, the KEBA decided that linear field shall then onwards to be given to the respondent, that is Monu Jilen. Full stop.
Moju, my lord.
Sorry, Moju Jilen. Next para. Being aggrieved by such decision of the KEBA, of the aforesaid KEBA, the petitioner has filed this instant civil revision petition under Article 220C of the Constitution of India, challenging the aforesaid decision on the following grounds. Number one, that the KEBA, which has decided the issue on 7th October 2025, does not have any jurisdiction as the first court under the customary laws of Arunachal Pradesh, as the first court as per Arunachal Pradesh code is the village KEBA, wherein either of the parties in dispute resides, or wherein the disputed land is located. Then number two, since the Inter-Village Council of Gaonburas, is an appellate forum wherein an appeal, wherein an appeal can be filed, disputing appeal can be filed challenging an order passed by a village Keba, the petitioner has lost one forum of appeal. As the matter was decided at the initial stage only by the inter-village council of Gaonwaras. That is number 2. Number 3,
Number 3 is the section 17, 1 and 2, interested party cannot take over.
Correct. On the third ground, is that the chairman of the impugned Keba, being a close relative of the respondent number 2, as per section 17 of
Honestly, for the Civil Court Act 17(1), my lord.
one second. As per section 17 of the Arunachal Pradesh Civil Code Act 2021, no judicial officer or authority of customary court shall try any suit to or in which he/she is a party or personally interested. Full stop.
My
This
lord.
code,
Yes, I sorry to interrupt, madam.
Mhm.
One of the reason for approaching this honorable High Court is that, madam, since I have been not furnished with a certified copy, so that I
That's
could
a
not
bad-
file my appeal before any.
that's a, I mean, that may not be a very legal, that
Yes.
can be,
Okay, okay,
it can be.
that's okay.
But only thing is that like 227, whether I can entertain this,
That only for
because you have not approached the civil court. But you don't have any other way.
Yes.
No other forum. The only thing is that you are saying is that, only because certificate copy was not there, you could not approach the civil court, correct? That is your submission?
that is only additional, my lord.
Hmm.
That is not the main code.
Hmm.
Because, my lord, the 17(2) is very also clear of this Arunachal Pradesh Civil Court Act. Which
No,
said-
that is,
So legal point is this 3 point. That's all my.
but with that point, you could have approached the civil court also.
Yes. So, my lord, that is okay, my lord.
Hmm?
That's
No,
only
no.
This
No, no,
3
we,
point-
this, all these points, you could have raised in the civil court also, why not?
So only because of this appellate jurisdiction, my lord.
No, since village council has passed an order,
Yes.
which you are alleging as illegal, you could have approached the civil court also, why not?
That's why, because I have because since I was not furnished with a certified copy.
No, that cannot be only a ground, because that point you could have raised before the civil court also.
So, my lord, because civil court will say that now there is some legal question of law, my lord, in this entire procedure. My lord. That's why I approached this honorable.
No, correct. That could have been decided by the civil court also, because your appellate forum is civil court, right?
Yes.
From whatever way, a order has been passed by the village council.
Yes, ma'am.
Correct. There's that inter-village council. So inter-village council order you are challenging. That you could have challenged before the civil court also very well, as per the law. Because why you have directly come to the High Court?
For taking the relief under supervisory jurisdiction of this honorable court, my lord.
No, supervised jurisdiction, this has to be exercised in a very limited and sparingly, that you are aware. So in this case, you have a forum, you could have gone there to the civil court.
Now, my lord, waiting for this certified copy, my lord, already the limitation period was over.
No, you could have raised those issues before the civil court.
My lord, in that case, the respondent will fell down, cut down entire trees available on the land. My lord.
No, but still that cannot be a ground for coming. See, supervisory reason is very limited. I
My
mean,
lord,
it
what-
has to be exercised in in very exceptional circumstances.
Yes, my lord,
Not as a routine matter.
here, my lord,
But like if there is any dispute in Keba and they directly come to the High Court, then I mean it will be difficult.
my lord, if now this, my lord, section 14.2, which speaks as appellate forum. Now,
Correct. So I mean, the one ground that you have taken is that that initial court should have been, the primary court should have been
yes,
the Keba, village Keba.
yes,
That is accepted, because as part this village Keba should have been the first court. But instead of going to the village Keba court, they have gone to the inter-village Gaura council. The inter-village Gaura council is basically a Vengo level. So
Yeah.
Vengo level is the second forum, right?
Yes.
First forum is the village Keba, second forum is the Bengo level. So Bengo level has now passed an order, which you are saying that they don't have the authority because they should have gone to the village Keba first. And you have taken other grounds also, that like chairman is a relative. Now thing is that like now since Bengo Keba, this Bengo level body has passed an order, he could have very well challenged it before the civil court. I mean, why you have come to the High Court?
my lord, this relief under the civil court is limited, my lord. Because
No. I mean, for the relief only, I mean, there has to be some extraordinary circumstances wherein, and like which has been, I mean, committed by the.
here, my lord,
Okay,
first is-
okay, then third. So the learned counsel, next learned counsel appearing for the accused, learned counsel appearing for the petitioner submits that there is a there is a legal flaw in passing of the order by the aforesaid inter-village council of Gaunviras, inter-village council of Gaunviras, as the inter-village council of Gaunviras is as per the Arunachal Pradesh code, is an appellate court rather than an original court as per the customary laws of Arunachal Pradesh. So therefore he submits that that the order which has been passed by the aforesaid council of aforesaid inter-village Gaunviras council. What is his name? Inter-village territorial customary court.
inter-village territorial customary court.
Inter-village territorial customary court consisting of head Gaunviras.
Gaunviras and head Gaunviras of different villages.
So it is called inter-village customary court
Yes, my lord.
or inter-village council of Gaunviras. What is it?
Inter-village territorial customary court.
It is not inter-village, inter-village council of Gaunviras. It's not that.
Not council, my lord.
Then
Inter-village
you
territorial
write
customary-
inter-village territorial customary court.
territorial customary.
Customary court. Customary court has gone beyond the jurisdiction, beyond its jurisdiction in passing the impugn order dated 7th October 2025. He further submits that one of the person, that is the chairman, being a close relative, he further submits that customary court as defined under section 2D of the APCC Act 2021 21 means a court of territorial council or authority of village, in bracket as villages indigenous to the state by whatever name call, and includes a court of village authority under section 5 of Assam Frontier, in bracket administrative justice, bracket complete regulation 1945. In terms of the aforesaid section, it is the village Keba, it is the local village Keba of indigenous people, which is the customary code as per section 2D of the APCC Act 2021. since in the instant case, rather than approaching the customary court, the respondent has approached directly the inter-village territorial customary court, and in view of the order passed by the inter-village territorial customary court is against the mandates of the APCC Act 2021. Therefore, the same is illegal. Same is illegal and liable to be set aside. He further submits that as per section 17 of the Arunachal Pradesh Civil Code Act 2021, no judicial officer or authority of customary courts shall try any suit to or in which he or she is a party personally interested. However, in the instant case, the decision was passed by the inter-village territorial customary court, wherein the chairman itself is a close relative of respondent number 2, who is in fact, what will be the relation? Who is in fact,
My lord, there is only sole respondent.
who is related? How he is related to the
He is
chairman?
the husband of the younger sister of this respondent.
He is in fact a brother-in-law of the respondent.
Yes, my lord.
Brother-in-law of the respondent. Therefore, being a close relative, the order passed, being a close relative of respondent number 2, wherein a dispute was placed, ideally he should have recused from the dispute, and the dispute could have been decided by the remaining members of the inter-village customary. What is that name? Inter-village territorial customary court. Therefore, he submits that the order, the decision of the inter-village territorial customary court being in violation of the statutory provisions as provided under the APCC Act 2021, the same is liable to be set aside and quashed. Full stop. This court has gone through the provisions of the APCC Act that have been referred to by the learned counsel, as well as gone through the materials brought before this court. Section 2D. Section 2D. Section 2D of the APCC Act 2021 provides for customary court, which is quoted herein below. D, you write, customary court means court of traditional council or authority of a village, in bracket S, indigenous to the state by whatever name called, and includes a court of village authority under section 5 of Assam Frontier, in bracket Administration of Justice, in bracket Regulation 1945. 1945, full stop. It may be relevant to mention herein that as per section 5 of Assam, as per section 5 of the aforesaid Regulation 1945, Deputy Commissioner is the authority who shall appoint such person in bracket S as he considers to be members of the village authority for such village or villages as he may specify, comma, and may modify or cancel any such order of appointment, comma, and may dismiss any person so appointed. So it is clear So it is clear that deputy commissioner is the person who is authorized by authorized by the aforesaid authorized by the aforesaid regulation 1945 to appoint the customary court as mentioned in section 2D of the or 2D of the APCC Act 2021. Therefore, it is clear that customary court is the original and primary court to decide the disputes under the customary laws of Arunachal Pradesh. Full stop. Where is the mention of this inter-district constituency?
My lord, may come to page number 12.
Page number 12.
Or in my petition or act law book, my lord.
Page number 12 we have mentioned.
Yes,
Section 15(4).
yes, my lord. At paragraph 12, my lord,
Yes.
at the bottom.
Mhm. It is also seen that under section 15(4) of the APCC Act 2021, an appeal from the village authority could be made before the inter-village territory customary court or apex customary court to settle the case. Settle the case as per local traditional customary laws under the provisions of section 40 of the Assam, 40 of the aforesaid regulation 1945. 45. In view of a careful reading of the aforesaid provisions, it is clear that only in the case of a party aggrieved by a decision of the customary court, the same can be laid before the inter-village territorial customary court or apex customary court. Full stop. However, in the instant case, the respondent has directly approached the inter-village territory customary court, bypassing the initial court, that is the customary court. Full stop. This court has also gone through the provisions prescribed under section 17 of the Arunachal Pradesh Civil Code Act 2021, which being relevant is extracted herein below. It take down from here 17. Section 17 makes it clear that no judicial officer or authority of customary court shall try any suit to or in which he/she is a party or personal interest. Full stop. It also provides that no judicial officer or authority of customary court shall try any appeal against any decree or order passed by him or stroke him, her in any other capacity. Full stop. The inter-village territory customary court also being a customary court, obviously the same could not have been presided over by a person closely related to one of the parties in dispute. Full stop. Next para. In view of the aforesaid discussion and coming to a prima facie finding that there is some violation in passing of the order, passing of the decision by the inter-village customary court on 7th October 2025 and 25 and prima facie finding some merit. This court is of the opinion that this case will require some further consideration. Full stop. In view of the aforesaid, let the notice be issued to respondent to the sole respondent by way of speed post, returnable within 4 weeks. Steps for notice shall be taken by the counsel appearing for the petitioner within 3 days of passing of this order. Full stop. In the meantime, this court, after finding prima facie material and merit in the case of the petitioner, directs that the further proceeding, that the impugned decision dated 7th October 2025 passed by the inter-village customary court, headed by, what was his name? Headed by
Jubin Romin, my lord.
Mr. Jubin Romin as the chairman, is stayed until further orders from this court. Release the matter after 4 weeks.
Deeply approved.
Item number 3.
Yes.
Lordship, this is civil revision petition,
Hmm.
assailing the order passed by the learned civil judge senior division Mutia.
Hmm.
Lordship, the petitioners filed title appeal against the order passed by Gambura Association of Mingyo Circle.
The Gambura Association is basically this inter-village customary court.
Yes.
Yes.
In fact, they have hearing my case, the respondents who are the respondents herein are from other village. Since they were remedialist, therefore they approached the Gambura Association.
But they have their own village keba.
They have their own village, but then the effect of the case is the petitioners are the permanent residents of Lengik village, one village called Lengik, which comes under Mengyo Circle. The respondents are now settled in other places. Some are in Papumpare, some are in Itanagar, some.
But they originally belong to those villages.
This is the case. What they are claiming that once upon a time, my ancestors were in that village, based on mere migratory narration, they are claiming back the land. There is nothing not on record to substantiate their claim. Only based on imaginary migratory route, they are claiming the land. Accordingly, they have approached the Mengyo Gambura Association, and in the year 2022, the hearing was conducted. No conclusion come out. There was no declaration or the order passed by the Gambura Association. Then the judges whom appointed judges from the Gambura Association, they orally declared that you possess the land. Since there was no conclusion, therefore they have just orally directed the parties to own their land and possess their land as it was. So that was the conclusion of the Niel or the hearing. Then suddenly in the year in the month of 2024, one respondent number, he started excavating land upon the land of one petitioner. Then this the one Lika Tagar, he complained, he protested, and he complained before the EAC Mengyo, because EAC Mengyo is the administrative head of that circle. EAC Mengyo intervened and he stopped the excavation. Again, in the month of June, he resumed the excavation, compelling that Lika Tagar, he lodged complaint before the PS Sagali. PS Sagali registered the case. Now the charge sheeted, it is undergoing before the criminal court. And he approached ADC, Additional Deputy Commissioner Sagali. He is the superior officer of EAC Mengyo. Sagali, EAC, he summoned both the parties on 19 June 2024, fixing hearing on 28 June 2024. They came, parties they came. During the course of discussion, hearing before the ADC Sagali, respondent number, he alleged that the entire Lengik village is ours, theirs, I mean like the respondents. It was decided, already decided in the year 2022 during the Keva, which was not, which is actually not correct, because there was no decision at all. Then, having come to know that there is some decision behind our back, the petitioner's back, then they started writing letters to the Keva judges, who were presiding over the Keva that in the year 2022. Then there was 5 Keva judges. Three Keva judges, they denied their attendance, their presence in the Keva. One, he didn't reply, and 2, they didn't reply the letter. So then these petitioners, they wrote letter to the EAC Mengyo, asking him to summon the respondents to produce the Keva decision if there is any. Then EAC Mengyo summoned them, given notice to them to produce the Keva decision. Finally, EAC Mengyo on 15/10/2024, October, he produced the Keva decision. Thereafter, after obtaining the Keva decision, EAC Mengyo, after obtaining the Keva decision, petitioners, they file appeal before the civil judge, along with the application for condoning delay of 677 days. This, the learned court below rejected the Keva decision, relying on the authority rendered by the Honorable Supreme Court of India in Isa Bhattacharjee and N. Narayan, wherein the Honorable Supreme Court has clearly, the authority rendered by the Honorable Supreme Court is based on hold that length of delay is immaterial if sufficient cause exists. That was the principle laid down in the case of N. Balakrishnan versus M. Krishnamurthy, reported in 1998. And other one, Isa Bhattacharjee and Managing Committee of Raghunath.
Now, what did it say? I mean, what was the ratio? It says that like if there is a merit in the case, the delay doesn't matter.
Yes.
So what is the wrong in that?
I have clearly demonstrated the sufficient cause, because I was unaware of the Keba decision. One second.
You have
only
not been
on the
given, you have not been given any notice in the Keba decision, by
No,
the
I
Keba.
attended because Keba was conducted.
But you are saying that like there was no, there was no, I mean,
There was no decision.
substantive order.
Yes,
Hmm?
yes.
Hmm.
There was no decision.
Hmm.
And even that is corroborated by the written reply given by the judges of the Keba.
No, but see, like there are two things. One thing is that like you are saying is that like Keba, you were there, right?
Yes, yes,
Now the letters have been written to the Keba members,
yes,
and some Keba members have denied it.
yes.
But you said that you have already appeared before the Keba. Then
We
where is the
appeared-
question of where is the question of not there in the, they are not present there?
No, we are not saying that we did not attend the Keba. We
No, when these letters were written to the 5 members, you said that like some of the members did not write back,
Yes,
and 2 persons denied it.
yes.
Then why they have denied it?
Because in the decision they have put their initial.
Hmm.
So what we are saying, submit, what we submit is, it is a forge in the Keba decision.
But you were there in the Keba, and that one decision, I mean, there was a Keba, and then the minutes of meeting of the Keba.
No minutes, no decision.
Hmm.
It was just went off
Hmm.
without any decision.
I mean,
Only
is there any document on Keba? What, I mean, have they produced any Keba decision before the civil court?
Yes, EAC has, because finally EAC has furnished the Keba decision to us.
Hmm.
After that only we have prepared the appeal.
Hmm. So how come this Keba decision surfaced then later on if EAC has given it?
It was furnished by the respondent to the EAC, because we have written letter to EAC saying that,
And so now you are saying that like that, I mean, those signatures were paused.
yes, we are saying that is one of the ground, and we have also lodged FIR before the police station Sagali after obtaining the this decision copy.
Now, I mean, what is the wrong in the civil judge's decision?
Lordship, we are residing in that place since our ancestor. Now, by this Keba decision, what they are saying is entire land is ours, theirs. May I invite my lordship to page number 39. I just this is the part of Keba decision.
Page number
39.
39. So this is the decision, I mean, which has been given by EAC.
No, this has been in our bag. This is purportedly demonstrating that this has been passed in the year 2022, which was not, which is actually not correct.
So that how now the High Court will decide on this?
I'm assailing the order because the my interlocutory application was for condoning the delay of 677 days so that I can, because appeal was filed. However, since I have obtained the copy of the Keba decision later, after much, so for filing the appeal, for admission of the appeal, this condonation application was filed, and the learned court below has rejected the delay condonation of 677 days. So I'm assailing the delay condonation, rejection order only.
What is their order?
Order starts from 32. And 39 is the operating portion whereby I am aggrieved because it's something like we 38, 9, 10, 11.
39, no, page 39, where is this?
8.
Point? Huh?
May I read 8?
That in future, any person?
Yes, that in future, any person who used to do respect or obedient to the Taba Abu Rate, they are the respondent. What they're claiming is the land belongs to them. They were the owner.
No, where is the order whereby your application has been rejected? You're challenging that order only, isn't
Yes,
it?
that order only. Page number 17.
Page number?
17, Annex 1.
Hmm.
while on presentation of the application, the learned court below has made 2 points for determination. It is in page number 18.
No, let us read 17.
17 it starts from 17.
Yes, yes, read.
Applicants are represented by learned counsel so and so and represented respondents represented by learned counsel so and so. The present interlocutory application IA number so and so has been filed by the applicants Sri Golo, Paso, and 9 others seeking under Section 5 of the Limitation Act 1963 and Section 151 CPC for condonation of delay of 677 days in preferring the connected title appeal against Aniel Mel decision dated 25/11/2022 passed by Gaobura Welfare Association Mengyo Circle concerning land at Lengik or Lengik Village Mengyo. The applicants seek condonation of a delay of 677 days in preferring the connected title appeal against Aniel Mel decision dated so and so concerning land at Lengik Village Mengyo. They plead want of knowledge of any concluded decision till an ADC Sagali hearing on 28 June 28/06/2024 and assert that they could obtain a copy of the decision only on 15/10/2024 after several representations in the months of July, September 2024, whereupon the appeal was filed on 28/10/2024 with this IA and earlier defective IA was withdrawn and refiled. The respondents oppose asserting knowledge in imputable from 25/10/2022 because the NIEL set from 21/11/2022 to 25/11/2022 and the applicants the cross relative attended and signed the settlement attendance copy of which is relied upon. Points for determination. Whether the applicants have shown sufficient cause under clause 5 of the Limitation Act 1963 to condone a delay of 677 days. Two consequences. Findings and reasons. The applicant's case rests on lack of knowledge till 28/06/2024 and difficulty in procuring the decision till 15/10/2024, notwithstanding repeated representations to NIEL judges and to the EAC Mengyo. They rely on replies from certain NIEL judges indicating non-attendance or non-availability of the copy to them. The respondents, however, specifically plead that applicants or their close kin were present and signed the NIEL attendance in the settlement on, and that the Lengik land dispute has been agitated since the 1980s and culminating in the land settlement deed dated 25/11/2022. On the materials presently available, I find the applicants have not satisfactorily explained one, the long period from 25/11/2022, date of decision, till 28/06/2024, claim first knowledge, and even assuming their version. Two, the further period from 28/06/2024 to 15/10/2024, copy procurement, and thereafter to 28/10/2024, date of filing. The applicant's own narrative shows active official interfaces in June 2024 at ADC Sagali, where the decision was disclosed in their presence, yet they waited nearly 4 months to secure the copy before moving the appellate court. It is obvious that sufficient cause must be shown for the whole period of delay. Mere assertions of difficulty in securing copy do not suffice when an appeal can be instituted on available particulars with appropriate steps for record copy thereafter. The plea that even certain NIEL judges lacked copies or did not attend does not explain the applicant's own inaction over the pre-knowledge period nor the lapse post-knowledge. The Supreme Court has emphasized that while a liberal approach is adopted in collector land acquisition, Anantnag and another versus Master Kartiji or others, and followed in N. Balakrishnan versus M. Krishnamurti 1988, the doctrine is not a license for indolence. Length of delay, want of due diligence, and prejudice are relevant as held in Isa Bhattacharjee versus Managing Committee of Raghunathpur Nafar Academy and others, 2023. On balance of the applicants explanation is bald and unsatisfactory for nearly 22 months, particularly in the face of the respondent's specific plea of attendance of 9 applicants of instant application except Sri Leka Tada, son of Leka Tagi, who are also signatories in Niel Mail decision dated 25/11/2022, along with their other relatives. In these circumstances, I am not satisfied that the applicants have made out sufficient cause warranting condonation of a 677-day delay. The equities also do not favor reopening a customary settlement said to have been participated in by the applicants with their other relatives after inordinate lapse when the respondents claim a position and development on the strength of settlement by Niel Mail in 2022. As such, instant
So you have challenged only this order,
yes.
but from where you can show that, I mean, no decision was taken?
It starts from page number 4.
How we can say so? How we can say so? I mean, there was no decision.
That is the point.
No, that is the point. You'll have to convince this court, I mean, that no decision was taken. But this court has, I mean, civil court has come to a finding the decision has been taken and you have been delayed in filing that civil petition.
No, civil court has categorically acknowledged the copy procured later on, late in the
Where it is, Mr. I didn't see anything.
despite of lordship in page number 18, it starts from on material presently available.
Where?
Down below on the materials
Presently available, I find the applicants have not satisfactorily explained
yes, and
the long delay. It doesn't say so.
no, second, the
Second.
satisfactory explain.
Ah,
One, the long period from date of decision. Date of decision is that
Hmm.
we doesn't know. What we are submitting is
No. What you are submitting is that you were, that decision was not in fact taken,
yes,
correct?
yes,
It was unclear.
yes,
Now here this court has taken into account the decision, correct?
yes,
They've taken into the account the decision and they've counted the days from there
yes,
while considering this condonation of delay petition.
yes,
Now this court has come, I mean, by doing that, this court has, I mean, apparently has taken, taken into consideration of the decision. It doesn't say so that decision is unclear or something like that. Now, from where you are saying
No,
so?
however, the reading below till 28/06/2024 claim first knowledge because this was the first knowledge of this decision.
You are claiming, that's what they are saying. You are
I
claiming.
am claiming because it is
No,
substantial.
see, this court has not come. See, here it says the present. I find the applicants have not satisfactorily explained one, the long period of from so and so. So 25/1/11/2002 date of decision he has taken into consideration.
Yes,
Correct. It's not that there is no, I mean, decision has been taken there.
yes,
So he is saying that like 25/11/2022 decision till 28/6/2024 claimed first knowledge. Decision was taken there and claimed first knowledge.
yes,
So this is your claim.
yes,
And even assuming their version, the further period of so and so, and thereafter so and so. So I mean, what is the wrong here?
no, even after there, when my submission is assumed to be true,
Correct.
then
Now,
the
now,
15 days
now,
is the
now the court is saying that even after further period of 28/6/2024 to 15/10/2024
15/10
20 and thereafter 28/10/2024, the delay has not been properly explained.
Lordship, the copy was furnished on 15/10/2024. I filed my application on 01/11/2024.
So he is saying that the further period of 28/6 to 15/10 is not properly explained.
28/06/2024 to 15/10/2024, I wrote several letters to the GVs because the possession of this decision copy was with the GV. Because in the meeting on 28/06/2024, he just narrated that the decision was taken.
Now, where is that? Where is that? Where are those letters? Where are those letters?
Lordship, page number 40. I'm just
Page number 40.
Page number 40, down below is the
Hmm.
name of the judges
Hmm.
of the Nyal.
Hmm.
One is Nabum Takia.
Yeah, that's fine.
Yes.
I've seen this. Then
Then page number 66,
one is Nabam Takian.
Nabum Takia.
Page number
66. 66 is the first letter that after coming to know that there is some decision behind our back, I've written letter to Golo Tariang
Hmm.
seeking of land, seeking copy of the land. However, he has not replied.
1 second.
Then
1 second. You are saying that I have come to knowledge that land settlement has been made between Abu Tabarate and villagers of Langik village in the year 2022, where you were part of 5 members, judge bench, which I had not known for. You said like you have been, you were present in the,
judgment I have not known for.
no, I mean, you're saying that like,
Now
I have come to knowledge that land settlement have been so and so known for. I mean, you have been a part member, judge bench, which I had not known for. What does it mean?
following the next, now I am being the interested party, I may ask a complete judgment copies of the land settlement, which I have the right to know the facts of that judgment, and you being the judge of that settlement. And Lords, next is the page number 67 is the another judge, Nabum Takyang. And page number 68 is his reply, Lordship.
Page number?
68.
Hmm.
May I read?
Yes.
Sir, in the wake of your application dated so and so, it is my pleasure to reply you that I do not have received such deed of land settlement copy as of now. Moreover, I was not present during the proceedings of that Nyal because of medical ground, although was appointed a judge in the circular copy for that Nyal. Now, it is fact that last week of December 2022, I was attending matrimonial dispute case at Paying area in Langik village as judge. One Sri so-and-so of Magang Panchayat and advocate so-and-so came to me and asked for signing in that settlement copy. At the same time, they told me that no any adverse settlements, statements are written there, or no any dispute will be happen in future. Hence, I put it my sign in that settlement copy by the instruction without knowing the facts, since I am an uneducated. Now I am very regretting for their misconduct or misleading to me. This is the reply furnished by
Okay, we'll take down. You are Mr.
Arkoyu.
I heard Mr. R. Koyo, the learned counsel appearing for how many,
10.
appearing for the appellants. Appearing for the appellants, full stop. This is an appeal file again. This is you filed as a civil division. Is you write that petitioner, petitioners or petitioners you write. The instant application under Article 227 of Constitution of India, read with Section 115 of Code of Civil Procedure 1908, is filed for quashing, for setting aside and quashing of the order dated 9/10/2025, passed in IN number 167/2024, in title appeal number 7/2024, in respect of the title appeal number 7/2024, in bracket you can write Sri Gollo Paso,
Yes.
Gollo Paso and others versus Sri Taba Talo and others, in bracket complete. By the learned civil judge, senior division UPIA, whereby the learned court has rejected the petitioner's application for condonation of delay of 677 days, despite sufficient cause demonstrated by the petitioners. Full stop. The petitioners and the respondents are involved in some land dispute, in some land dispute. In which village? Land dispute in Langik village. Due to such dispute, what was the meeting? It will be called as NEL, but
Niel.
uh,
NY.
I mean, in respect to the dispute, a NEL was held from which date to which date? From
21. 20.
see properly. 21.
21/11/2022 to 25/11/2022.
22. Before what? Before which committee?
For Gaopura Welfare Association of Mengyo Circle.
Nenge Circle.
Lordship would find that in page number 38.
Menge Circle. Menge Circle. However, it is contended by the petitioners that no effective order or decision was taken as far as the right, title and liabilities of the land in dispute was concerned. Full stop. However, full stop. Subsequently, the petitioners found that the respondents have in fact trespassed on their land and started doing certain art cutting in their land, and in view of the aforesaid and land, and in view of the aforesaid, the petitioners has lodged a complaint before the ADC.
ADC 7.
Before the ADC Sagali. Sagali, when? Where is the complaint?
Complaint is at page number 63 and it's
Page 58.
63.
What is this 58? Fifty-eight is the
58 is the before ADC EAC Extra Assistant Commissioner Mengyo Circle.
Then he didn't take any action.
No, he stopped Again, in the month of June, we resumed the excavation. Then we filed complaint before the ADC Sagali.
Okay, then, complaint before, page 61,
Page 63.
63. Before the year, on 12th June 2024, 2024. On filing of the complaint, the petition, filing of the complaint, it is the contention of the petitioner that the petitioners that they came to know about the alleged land settlement.
On filing of the complaint on 12/06, ADC issued one summon on 19, fixing hearing in his chamber on 28/06/2024. There on 26 only we came to know that because illegally was claimed.
You write that on receipt of the complaint, the ADC, the concerned, the ADC summoned notices to the petitioners as well as the respondents,
Respondents also.
as well as the respondents to appear in his chamber. And during the course of the hearing, the petitioners had come to know that there is a land settlement. There is a land settlement order allegedly passed by the
Gambura Association
passed by the Gambura Association on
22/10/2025. 2022.
where is that page?
Page 21. 25/11/2022. I'm sorry.
On so and so. But this is the same nail they are saying, right?
Yes.
They are saying the same nail that you were there
Yes.
and so and so. You written the data? So and so. In fact, the the petitioners contended that they were taken by surprise by such land settlement decision passed by the aforesaid what was that? Aforesaid
Land settlements.
land settlement deed. But in the land settlement deed, your signature is not there.
These in our attendance, we put our signature. But then in
But
the land
but it's a land settlement deed.
having after obtaining this settlement deed only, we come to know that our signatures are being forged.
No. That is not a contention you have made before this thing, made before the civil court.
No, we have made before the civil court that contention, and even to that effect, we have filed lodged complaint before the police station.
So you was suggesting that the whole this land settlement deed, I mean, it's about 18-19 pages, wherein the signatures are there, all signatures are forged.
No, not all.
Then-
We don't know because in the attendance sheet we put our signature. That is
No, that is it. I mean, otherwise, I mean,
otherwise we don't.
no, I mean, how come you? I mean, who are you? You are Tabatalo.
No. Tabatalo, they are the respondent.
And like this Taba taking and all.
No, I am Golo Paso, petitioner.
Golo Paso is
Golo Paso is reflected in serial number 2.
your signature is there. All the person's signature are there.
These we are contending that these are not our signature. So that can be substantiated only by way of trial. That is our contention. So that
What was the last line? Surprise by the land settlement deed. Land settlement deed as they never put their signatures on any such land settlement deed of Langik village, Mangio. And Langis Mangio in the aforementioned NIL conducted on so and so date. That was there no? From this to date, so and so. Full stop. Full stop. The petitioners contended that since they did not have any copy, any certified copy, any original copy or certified copy of the settlement deed, which was alleged to have been prepared behind their back, they have requested for a certified copy of the same from the aforesaid members present in the NIL, aforesaid judges of the NIL, by writing letters and representations. Full stop. It is the contention of the petitioners that it is further the contention of the petitioners that in spite of writing to the judges, they could not receive any proper response. They could neither get any proper response nor receive any certified copy of the aforesaid land settlement deed. Full stop. Land settlement deed. Full stop. Then when do you have? I mean, when did you get it?
Then fail to get copy from the judges. I have written letter on 11 September 2024. This is in page number 7
To whom?
to the EAC,
Hmm.
Administrative Extra Assistant Commissioner.
Then EAC has directed them to give you.
Him to furnish copy in his office. From the office of the EAC, we
Received it.
received the copy on
Ah.
15/10/2024.
Facing with that situation, the petitioners have written a letter to the EAC Sagale,
EAC Mengio.
EAC Mengio, complaining that in spite of their writing several times to the judges of the aforesaid NIL, they have not been given any such certified copy. Full stop. On receipt of such complaint, the aforesaid EAC procured a copy of the settlement deed and delivered the same to the petitioners on 15/10/2024. 24. Full stop. After receipt of the copy, the petitioners have filed the title suit, right?
Title suit.
Title suit along with a petition for condemnation of delay of 677 days.
Yes.
677 days in filing the connected title suit. Full stop. Next paragraph. The learned counsel appearing for the petitioners submit that the delay has been properly and adequately explained in the petition for condemnation of delay, which was apparent from the body of the petition. Full stop. He submits that since they were not aware of any such settlement deed which was alleged to be made between the petitioners and respondents, and the fact of such existence of any settlement deed was only known to them on when was it? I mean, what is the order? Only on
Page.
28/6/2024. Thereafter, they wrote several letters and letters to representations to the members of the aforesaid NIEL, members stroke judges of the aforesaid NIEL during the period of white letter dated 10/7/2024, 13/7/2024, 10/9/2024, 16/7/2024, 17/7/2024, right?
No, 18. 17 is the
His reply. 18/7/2024, etc., etc., etc. However, they could, however, no proper response. However, on being not received of any proper response from the aforesaid members, the petitioners had approached the EAC Mangyo on
on 11/09/2024.
11/09/2024, and thereafter only on
15/10/2024.
15/10/2024, a copy of the same has been received. And thereafter, immediately within a period of how many days?
15 days.
Within
On
a
28.
within a period of 15 days, that title suit was prepared and accordingly filed on
01/11/2024.
01/11/2024, before the learned
Civil Judge Senior Division.
Sin-
Yeah.
Civil Judge Senior Division UPI. Therefore, he submits that there is no intentional delay, and whatever delay that has occurred due to their absence of knowledge about the alleged about the existence of the alleged settlement deed and non-procurement of and non-receipt of the certified copy of the aforesaid settlement deed from the judges of the aforesaid NIEL. Therefore, he submits that there is no intentional delay, and the delay which has occurred has been properly explained. But the learned civil judge Senior Division Papumpare, UPIA, without proper consideration and application of mind, has rejected the application for condemnation of delay by order dated 9/10/2025, which is apparently not correct and liable to be set aside. Full stop. This court has gone through the material brought before this court as well as the order passed by the impugn order passed by the learned Civil Judge Senior Division Papumpare UPIA dated 9/10/2025. Full stop. Having heard the submissions made by the learned counsel appearing for the petitioners and having found the prima facie merit in his submission about the explanation of delay in his delay condonation petition, in his condonation for delay petition, by I number 167/2024 at paragraphs. Which paragraphs? Your explanation of delay. This is the most important thing that you should have been. You should prepare. I mean, be ready with the paragraphs, because you are challenging that order.
Is in the paragraph 2.
Hmm?
2.
Paragraph 2. How can it be paragraph 2? No. That, I mean, where you have stated that, how you have explained that the delay has occurred for these days because of this, where? Paragraph 8(2).
Eight to 22.
Paragraph 8 to 22. 22. Mm. What was the, how I have started? Mm. 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 Correct. This court feels that the instant case will require further detailed consideration. Full stop. Accordingly, let the notice be issued on the respondents by way of speed post. Full stop. Returnable within 4 weeks. 4 weeks. Then you write steps to be taken. Steps for notice to be taken by the learned counsel appearing for the petitioners within 3 days of passing of this order. Then write in the meantime, the order, till the disposal of this, of the instant petition, the order dated 9/10/2025, 25 shall be stayed. Release the matter after 4 weeks. Then on consideration, if there is material, then it's fine. Otherwise, you're gone.
Item number 4.
Yes, Mr. Tara.
Ballad, while laying my hands on the brief this morning,
Hmm.
I detected certain shortcomings in this application.
Okay. You want to correct it?
I want to withdraw this with the liberty to file FRS.
Okay. Heard Mr. T.T. Tara, the learned counsel appearing for the petitioner. He submits that while filing the instant application, certain defects remain, and he would like to correct those defects by filing a filing a fresh petition. Full stop. Yeah, fresh petition. Full stop. His prayer for withdrawal of the petition is granted with the liberty to him to file a fresh one. Accordingly, the instant CRP is dismissed as withdrawn. MS so-and-so, who?
Respondent number 2.
MS so-and-so appears for respondent number 2.
Well, may I request, instead of word dismiss, closed.
Okay, closed. I like using dismissed.
Item number 5.
And DPS. So we'll issue notice on this.
Yes, my lord. This is just for non-appearance. Accused was arrested for the non-appearance of this.
Hmm?
Non-appearance, accused was arrested
Hmm.
for non-appearance during the trial procedure.
Yes, then he'll be arrested obviously if you do not appear.
But there certain circumstances were there.
What circumstances are there? You do not, where you have stated?
On
Hmm?
on 7th March, the NBW.
But we will require a CD, isn't it? In this case, we will require a CD,
Yes, yes.
otherwise I won't be able to consider. So it's, I will have to issue a notice.
Yes.
But what was the fact otherwise?
My lord, on 7th.
Okay, we'll issue a notice in this case, okay? I mean, nothing much is required. at this
Seems
stage.
Yes.
from the last orders,
Heard, Mr.
DNMA.
Last order, where is last order? Is a fresh petition, is it?
page 21.
Huh?
This was passed by the London Special
No, no,
Court.
that will be considered later.
It matter was supposed to, it is charge sheeted, already charge sheeted, then this year,
Now, correct, this year is to be.
Yes.
Yes.
Heard, Mr.
DNMA.
Remember the learned counsel appearing for the accused applicant also heard Mr. So-and-so, the learned APT for the state. This is an application under section 483 of BNSS 2023, praying for granting bail to the accused applicant in connection with NDPS case number 40/2023, corresponding to Itanagar PS case number 270/2022. under section 21 in bracket B of Narcotic and NDPS Act 1985. And it will call, I mean, registered to call for the PCR in the instant case from the court of, which court?
Session court.
Session court? UPIA?
Yes, UPIA.
Session court.
Session court, UPIA.
Sessions court, UPIA. Registered to call for the scan copies of the PCR from the sessions court, NDPS UPIA. List the matter after.
My lord, since
There is no other party, no, state only is the party,
it's only state is the party.
state is the party.
Yes.
List the matter when, after, list the matter on,
On Monday itself, my lord,
Huh?
if possible, on Monday itself. Because accused is in custody since 160 days, more than 160 days, just for non-appearance.
charge sheet matter.
Yes, it is charge sheet
Then-
matter. No, I'm not,
If it is a charge.
I'm
sheet
not
matter.
paying.
This is all about communication between court to court.
Okay, then we'll. fix-
Calling of charge sheet is.
Huh?
Calling of charge sheet, PCR is all about matter of court to court communication.
So, I mean, how much time it will take? And that's what I'm, so we'll fix it in,
After receipt of charge, TCR, after receipt of TCR.
no, that cannot be done like that. After, let the matter be fixed on 23rd of December. Okay,
If possible, my lord, matter may be taken earlier.
then earlier than which day? And today is what? Today is, then let the matter be fixed on 19th,
Yes, my
19 December.
Item number 6.
Yes, madam.
Lordship, the instant case is registered in the Narlagad PA.
Arms Act.
Yes, on sex.
So you are behind the bars for how many days?
105 days.
105 days.
Yes.
So, I mean, charge sheet is filed.
Yes.
Yes.
Charge sheet is filed.
Already filed.
What is the ground of bail?
So there is an urgency in the medical ground. The accused minor son is suffering from the heart disease. So doctor referred to the outside treatment. Page number 29 in the refer order.
29, it can't be read only. You haven't typed it out. But these documents are pretty old. This is in the month of October.
Yes, sir.
Her name is Payal Ebia, that daughter.
No, sir. He's the niece. Son is the Tinbom Sium. And
But this is from some.
Payal Evia is the niece. He also taking care of his niece because of her parents is both parents is dead in the accident.
Both
Niece,
parents?
Payal Evia parents both are in the met in the accident. So
So
He-
Payal Ebia is staying with, I mean.
yeah, Payal Evia is also suffering from kidney infection. So he is the sole earner of the family. So in
So you are giving all Payal Ebia's document.
yes, sir, both documents have been annexed.
Tinbom Sium to see, I mean,
Yes. From the 29 to 31, the Timbom Sium documents and
no, where is this? I mean, it says diagnosis is perfectly fine. Goodbye function, it says,
Yes. Annexes 5.
where is the document? Wherein you are saying that like she is suffering from heart disease and needs very urgent attention. Where is that? Madam. Only cardiology is suggested. I mean, that doesn't mean that like he has got serious problem. Where is his mother?
she's in the
I mean, this Tinbom Sium's mother.
she's in the Itanagar, staying in the
She's staying with the kid, right?
yes.
Then
She's unable to take because he is the housewife.
no, that's fine. But she's there. I mean, now a person is in jail for certain offenses,
So,
and I mean, it doesn't show any serious medical problem, and that this girl is, of course, 18 years of age. She also doesn't, I mean, look to be. You show me where the serious medical condition is there. Madam, there is nothing in this petition. I have to reject it.
sir, please.
Hmm?
Sir, this is the last option for the petitioner. We
No, I mean, see, I mean, you have been in jail, I understand, but charge sheet has been filed and it's under NDPS.
Sir, I have already
No,
exhausted from
arms act.
earlier
Arms act.
remedies.
Hmm?
Sir. I have already exhausted all the earlier remedies, sir.
You have already?
Exhausted earlier remedies. I have approached the board before.
But it's under the Arms Act. Arms Act is critical.
Section 25, capital 1 and capital D. Okay.
Section 25 of Arms Act.
Yes, and stop section 27, 1. Arms Act. Read with
Give it to me.
25 is possessing, 27 is using of the fire.
Twenty-five, which clause will be applicable in this case?
Page 20. Page 20 of the BR Act.
No, which section? Which section?
A.
Section
Clause A.
Hmm.
1B.
Aqueous.
No. 1 capital B.
One capital B.
Section,
acquires
section 25, subsection 1B, clause A.
Clause acquires and has in possession or carries any firearm, ammunition, so in section 3 shall be punishable with term of less than 2 years. Isn't it? Or it is more than that?
it's up to 5 years, extended up to 5 years.
Hmm?
Extended-
Yes, extend up to 5 years.
1 year, say 1 year.
20 27(1) is punishable up to 3 years. Page
So
21.
he is already inside the jail for how many?
105 days.
105 days. In charge sheet is already been filed.
Yes.
Yes.
So why don't you go and approach the trial court?
Sir, I already approached the.
When?
Uh,
9-10.
It's the page number 16 to 21.
Hmm?
I approached the before the CGM on 15/09/2025, the order dated. And before the charge sheet that I already filed the bail on order dated 9/10/2025. After the charge sheet, I also filed the bail applications on before the session court.
Where is their order? Yes.
Annexure 2 series, page number 15.
So we'll call for the CD, we'll see what is there, what material there. Huh?
Okay.
Then we'll consider, not today. Hard
Is-
MS,
This year, your office.
Huh?
Charge sheet.
charge sheet, PCR will call, we'll give a short date.
Okay.
Then we'll consider on the next date, if there is no material, we'll see, consider it. Heard MS,
YMOC.
so learned counsel appearing for the accused applicant. Also heard Mr. So-and-so, the learned APP for the state. Reason application under section 483 of BNSS, praying for bail of the accused applicant, accused person, accused applicant in connection with NLGPS case number 115/225 under section 113 in bracket 3, BNS read with section 25 in bracket 1, 1 dash capital B, small a, stroke, section 27 in bracket 1 of Arms Act corresponding to GR number 752/25 full stop. The case of the petitioner is that the case of the applicant is that applicant was arrested by the Naharlagun police station on 29/8/2025 under the charges under section 117 in bracket 3 BNS read with section 25 in bracket 1 dash capital B small a stroke section 27 in bracket 1 of Arms Act arising out of the FIR dated 27/8/2025 and since then he is in judicial custody since then. It is also submitted contended that the charge sheet in the instant matter was filed on 7/10/2025 full stop. The learned counsel appearing for the accused applicant submitted that there are submits that the accused applicant has one minor daughter of 6 years as well
Minor
as
son.
minor son of 6 years, as well as a niece of 18 years whom he needs to take care of, full stop. Or take care of, full stop. However, the both of them are suffering from certain serious diseases, which could be serious diseases, and for that immediate medical attention is required. She submits that the mother of the child being minor child being an illiterate housewife, she could not take care of the child. Therefore, on special medical ground, the accused applicant should be released on bail. Full stop. On perusal of the matters and the documents and medical documents submitted before this court, this court is of the considered view that TCR in the matter would be required for proper adjudication of the case, and would be required for consideration of the prayer of the accused applicant. Full stop. In view of the aforesaid, registry to call for the TCR in connection.
Scan.
Scan copies of the TCR in connection with what was the case number? In connection with Naharlagun PS.
GR number is also there.
In
GR number 7.
in connection with GR number 752/2025, pending before which court? Pending
CJM.
before Chief Judicial Magistrate. Chief Judicial Magistrate, UPA. UPA, full stop. Let the matter be listed on when?
Sir, 17.
Let the matter be listed on the 17th.
Published.
Chabla.
Item number 7.
Your Lordship, this is the same case which was heard on 10th November.
The murder case,
Lordship, there was my,
arrest and negligence case.
yes, Your Lordship.
Hmm.
Your Lordship, in this, I would like to submit 2 citation. Your Lordship, the first citation that is Ojindarim and 2 others versus State of AP.
1 second, let me see. This the other case is only, I mean, these were for the injuries.
Yes, Your Lordship.
Hmm?
But 307 and 326 is involved in there. There is a non-compoundable case, Your Lordship.
And
For that reason,
non-compoundable, see, there are a lot of cases, offenses which are non-compoundable. Murder is also non-compoundable, dacoity also not compoundable. Those are heinous crimes, and heinous crimes you'll have to be very careful about. I mean, it can't be compromised. I mean, in each and every non-compoundable offense cannot be compounded just like that.
Yes.
Correct. So, in this case, I mean, whether you have come to a settlement, where is the settlement?
settlement, I have submitted as a additional affidavit, Your Lordship.
And have you paid some compensation?
Yes, Your Lordship, I have paid
How much?
8 lakh, Your Lordship.
Hmm.
But it was not mentioned in the settlement agreement. But money receipt is there, Your Lordship. It is with complainant, Your Lordship.
No, why the amount is not mentioned? See, it's a motor vehicle accident case.
Yes.
So per person has to be compensated.
Yes, Your Lordship.
If you have paid it, then I mean, why these two settlement agreement? Or one, no?
Yes.
What is this
Your Lordship.
additional affidavit? But you haven't mentioned about any money paid.
Yes, Your Lordship. But the compensate, we have already compensated, but it was not mentioned in the.
Yeah, I mean, where you have a receipt.
Yes, Your Lordship, but I have not procured.
If you don't have it, then how will you consider this?
Since the money receipt is with the complainant and due to the election.
No, you should have kept a copy of the, I mean, copy wherein that compensation has been paid. See, now, if only on the basis of this, it may be, I mean, it may not be voluntary also. How do I know it?
Authorization letter also there in petition, Your Lordship.
What authorization?
That for filing this quashing petition, the authorization letter from the petitioner number 2, that is informant.
Yeah, that's what, I mean, what I'm saying is that, I mean, authorization is there. And you have, I mean, I'm not, I'm saying that like, I mean, you have, without the knowledge of the other person, you have filed it. You have bona fide filed it, and there is a compromise. There is no doubt about this. But as far as like, I mean, court has to look into other things also, whether the compensation has been paid or not. There is some equity issues are there. A person is dead from the other side. And now you are coming with that, we have come to a compromise. It can be, I mean, it may not be voluntary also. I mean, if you can show that there is some money paid as compensation, because it's not an intentional thing. There is it's a rash and negligent thing maybe. The element of rash and negligence may be there. But thing is that court has to look into the equity also. The other person is, has lost his life. Person has lost his life. You should have come up with your this thing, the receipt that you have paid because it's a motor vehicle accident case. Otherwise, also compensation is one of the, one of the relief that is paid to the family of the person deceased, right?
Yes.
It's not like, other homicides. Other homicides, state is a party, then you cannot do all those kind of things, paying compensation, you cannot compound. But this kind of cases, usually what happens is that usually in the MSCT tribunal also, if you go, then compensation will be paid. And usually nobody is jailed or something like that for that, because it's a rash and negligent driving. Some cases, peculiar cases may be this thing, but you should have come up with this receipt. What is to be done? You can bring it
Yes, Your Lordship.
after 2 o'clock.
2 o'clock. Okay, I will try it.
You can try it, or you can give me the details of the money paid.
Yes.
Then I can record in the thing that money has been paid, and because coordinate bench has already passed an order.
Yes, Your Lordship.
So we'll have to maintain this, and I think if you have already paid 8 lakhs of rupees, and it's an accidental death, then it can be compromised. So since coordinate bench has already done so. So we'll do it, but you give me the details of money receipt and all.
Okay.
You come after 2 o'clock.
I know.
MS, I mean, Hagia has to be there now till 2 o'clock.
Lordship. Mashallah.
Item number 8.
Yes.
Well, if this is a joint petition, where petitioner wants victim informant and petitioner must be that person.
What kind of allegation?
Allegation, lordship may kindly come to page number 18, that's the FIR. Uh, 19 is the typo. Married.
Hmm.
It is set to inform details on the one game she so and so, son of so and so, of village so and so.
Attempted rape and murder.
That is the allegation. However, after the investigation and investigation charge sheet was filed under section 448 and 354C for criminal trespass and voyeurism.
Hmm.
However, lordship,
You know, where is the settlement agreement?
page number 69.
'69.
Yes. Second last.
Okay, we'll pass an order.
No, sir.
Medium. This seemed like that. Some factual thing will be changed. Your name?
Yes.
Just write down the name, I'll have it. APS for so and so, and then I'll pass the order. It will be same order. It will be disposed of.
Alright.
Item number 9.
May I please, Lordship, in this criminal petition, we have approached this honorable court for quashing of the FIR and the charge sheet, and in charge sheet, mainly on ground it's a civil in nature, man. Now, what happened is the present petitioner, 4 fathers were settled in a particular place, and long before we had
It's come for the first time. We'll issue notice on this.
we are trying to pray before the proceeding may be suspended,
Property proceedings, I mean, without hearing them, I mean, how?
Proceeding before the learned trial court.
And what was the proceeding?
Charges have been framed,
On the
Now-
447,
447, 427.
Charges are framed is bad.
Yes.
Framing of charge is bad.
Yes,
How?
Now, Your Lordship, that's why, kindly see the page.
I mean, this is, related to that case.
Yes, somewhat, but these parties are different.
with item number 3, lordship.
Hmm?
With item number 3, lordship. Connected.
Yeah, I mean, that
Effective-
settlement deed.
Yes,
Fact is almost same, lordship. Number fact is same, lordship.
but the parties are different.
Yes.
What happened, the particular present petitioner, by this settlement agreement, this is a Kebab Niel decision, Your Lordship just might have heard. This is a traditional, this is,
But like, those petitioners are not involved here. Petitioners and respondents in
No,
the case.
no.
Because it's a dispute between those 2 parties only. How
Yeah.
come you got involved in this?
No. In that, they are in that petition.
You also one of the
Yes,
party.
Yes,
You are the respondent or the
yes,
petitioner?
respondent.
You are the respondent.
Yes.
Okay, then,
No,
I mean, against you, a case has been filed by the petitioners.
No, but some third person, this present criminal petition, criminal case. What happened, by the settlement by the village authority,
Correct.
the land has been given to me. And I wanted to construct a road so that I can settle in that particular place. Now, the Niel order is very clear that after 92 or after 1982 or before 1982, who were settled in that particular place.
But that is in dispute now.
No, that's not with this particular complainant, That was the decision by the village authority. Now I tried to construct a road. Now he comes in 2016, in that particular case. Now, how he's will have the ownership, because ultimately he not been given the rights in that settlement.
But anyways, right or wrong way, he filed a complaint against you,
Yes.
correct? And in the complaint, in the investigation, a charge sheet has been filed after
Yeah.
investigation. And charge sheet has been filed against you. So now you need to convince this court that the charge sheet is incorrect.
Yes.
So how you are going to convince it?
Now, Lordship will see, even if it's a charge sheet, madam, the only allegation is a trespass, main allegation. Of course, 297, that's a burial places, and that has been not proved in the charge sheet also. Madam. The only ingredient is 447, trespass. Now, madam, that is my land, madam, according to the decision of the village authority. How a third party can now say that his land has been trespassed? Because he doesn't have the right or title over the land. If he has the right title over the land, then only he can file a complaint of trespassing.
Now, where is the order? Where is the order that you have, I mean, cognizance has been taken and
Yes, madam.
charge has been framed?
Yes, madam.
Huh?
Page 67, last page. Madam.
Page 67.
Yes, my last page. Today, give me lordship, case ethics for offense explained, accused person, namely, Tawa Talo is present, then such and such is present, then PPM is absent, according to panel of L, sessions appointed today, heard the learned council. Then if we have submitted the offense under section 447, 427, 297 IPC made out, Learner DC has objected to the state of sections and prayed that accused may be discharged on the ground that the instead case is purely civil in nature and accused has not committed the alleged offense of destroying the gardens because of earth cutting. That said land is his ancestral land and is being developed by the clan members of the accused for settlement of, and preservation of their ancestral land. Since the present land is presently covered with trees and other vegetation, it is difficult to trace the exact location of the tomb which claimed to be the ancestor of complainant. Peruse the case record on going through the materials on record prima facie, offense under such and such are established against the accused by accordingly substance accusation under such is read over and explained the accused person is in the language person I understand accused pleaded not guilty and claimed to be tried. Malad, no explanation, nothing Malad, in this. How the materials are made out. It's clearly mentioned ancestral land, Malad, and the petitioner has the right and authority to do anything on his land. This is a third party, Malad.
Where is the charge sheet? Charge sheet have you in annex?
Yes, yes.
Page?
Malad, it starts from page 33.
Page 33.
Yes. Malad, relevant would be page 38.
Yes.
Yes. Such a second para, Malad, just skip first para. On receipt of the case, whites such and such section such was registered and endorsed to the understanding for investigation. Place of offense was visited, photograph taken, rough sketch map drawn, and available witness were examined and statement under section 161 CRPC. It's observed that POs approximately 1 kilometer from their present location of house of the complainant, and they have shifted to their current location in 2016 month. This may kindly. With the orange garden found to be destroyed by the earth cutting in the graveyards, as shown by the complainant and other witnesses were marked, no permanent structure or grave could be found, and reason not toll being not available of rods, cements, etc. Therefore, LSC Tawa Talo settled in the said disputed land long time ago, but due to conflict and war with other clan members that deserted the land. But the forefathers of the complainant settled the said land for more than 3 decades. The elected person was served with a notice under section 41A CRPC, according to statement of alleged person was reduced on 161 to 24. Sagali police station, alleged active was not arrested as he complied and cooperated with the notice. Investigation as well, and work of earth cutting and PO has been stopped by him. Based on above facts and circumstances, complainant and otherwise Sagali police station case number such and such is submitted into charge sheet by Sagali case charge sheet number 1424 under section 447, 427, 279 IPC. Therefore, send the alleged accused person Sri Tawa Talo, then late Tawa Jabal to the Honorable Court for case trial witness mentioned in the column number 13 will prove the case and maybe someone after fixing the date of it. Here also is very clear, Malad. This is the ancestral line of the petition. Even in the charge sheet. how a case under 447 could be made out?
Let's see what is 447, 427, what is there.
Yes.
This-
447, criminal trespass.
Correct, correct. Let's see the indicators.
Yes.
No, IPC, give me IPC.
IPC. This definition is 441.
Yes.
Definition lawshipability. Whoever enters into or upon property in possession of another with an intent to commit an offense or to intimidate, insult, or annoy a person in possession of such property, or having lawfully entered into or upon such property unlawfully remains there with intent thereby to intimidate, insult, or annoy any such person or with intent to commit an offense is said to commit criminal trespass. 447 is punishment. 3 months, Manoj.
So it's basically a civil dispute.
Yes.
Lordship, the fact, yes, basically civil dispute, but Lordship,
The only thing is that
Ye-
criminal trespassing is there.
Yes,
Trespassing element is there, and, element is there.
yes, they destroyed the orange orchard, Lordship, guava, fish, and graveyard, Lordship.
Property has been declared
And-
in my favor, but they.
Who has destroyed it?
The petitioner, Lordship.
The petitioner, I mean, he says it is his land, but that's what I wanted to ask you.
No, no, Lordship.
If it is your land,
Yes.
then how orange orchard is there?
That is the already described in that the Kebab Niel settlement. There are people, that's
No,
why
it-
the Niel was said, because many people started encroaching upon my land. Our
So,
plans-
I mean, but so you straight away went and destroyed this
no.
plantation.
We had not destroyed, the whole clan members were constructing. It's not my alone construction. The whole clan members wanted to settle them for permanent because so many encroachments were going on.
But you should have at least, when given a notice to the, owners of the orange garden, at least, who was owning it. That notice should have been given, and why you destroyed somebody else's property without giving a notice?
In such an interior place, such kind of, the villagers wouldn't even imagine of giving notice.
No, not notice. I'm not on notice. I'm not saying about like you issue a notice from the post office. At least you go and intimate the villagers.
Inform Lordship.
Intimate the villagers that this is the thing that Kebab decision has come, and this is this. I mean, like if your orange plantation is there, you plug those oranges and like we'll have to make a road, something like that.
The complainant knew about the Kebab decision. He's one of the persons, in that around the Langin village. He's one of the encroachers of the property. He knew about the decision. Yeah. That also after 2 years, this was carried out after that decision, not suddenly.
Only notice may be Lordship issued, Lordship.
It will be unnecessary trial. Kindly issue notice. We have made the complaint as one of the respondents.
On the returnable debt, Lordship, if
No, we'll straight. I mean, see, this is, this is on the face of a Kebab decision. I mean, the Kebab decision says that land is his. As of now, if though Kebab decision has been, they are now, I mean, he's under challenge. That's a different thing. And another thing is that he is not part of the Kebab decision. He's a third party.
Yes.
isn't it?
Yes, Lordship.
He is a third party.
But
O-
if-
Only in
yes,
Keba decision, only four persons, my lord, who were settled there, who looked after us when we became orphan.
Okay, we'll give a,
They were allowed.
we'll give a interim, and when the case diary comes, that will be definitely considered.
Yes.
And once, I mean, if you find out that certain materials are there, I mean, then it can be, I mean, always it can be modified
Yes.
and cancelled.
I leave it to Lordship. Though in the Lordship, in the statement, Lordship, the witness stated that they reside in there in last 3 decades, Lordship, in the respondent, Lordship.
Okay,
Yeah.
that, there, I mean, those things will be considered, it can be considered only upon receipt of the case diary and all. I mean, in this case, charge sheet also, I mean,
TCR.
TCR is to be called.
And we have made the complainant as a party here.
Mm.
We will also would like to answer, madam, regarding this.
Okay, we at 2 o'clock we'll pass the order.
Yes. Obliged.
Yes. We'll state for time being next, till next day.
Yes.
I missed your name,
Pritam Tapo, madam.
Pritam Tapo, yes. Heard Mr. Pritam Tapo, the Learned Council, appearing for the petitioner. Also heard Mr. D. Loy, the Learned Public Prosecutor for the state. This is an application under section 528 of BNSS 2023. Praying for quashing and setting aside of the impugn order dated 19/9/2025 passed by the CJM UPR. UPR in GR case number,
Yes, madam.
in GR number 686/2024 arising out of Sagali PS case number 11/2024 under section 447/427/297 of Indian Penal Code. it is the case of the petitioner as the petitioner is that petitioner is the lawful owner of the of a plot of land which is located at Langik village
Yes.
under Mangyo circle. Full stop. This land, though there was a dispute regarding the ownership of the land between the relatives of the petitioner, between the relatives of the petitioner, the same dispute was settled between settled by the decision given by Neil, given by Neil, and accordingly a settlement agreement dated 25/11/2022 was executed. Full stop. By the aforesaid settlement agreement, it is clear that it is contended that by the aforesaid settlement agreement, it is clear that the concerned land belong to the petitioner. Full stop. There are certain other lands which were also settled for his relatives. Full stop. In view of the aforesaid settlement agreement by an authorized Neil, the petitioner became the dispute over the land has already gone, and therefore petitioner wanted to petitioner along with his
Clan
family
members.
Clan members. Petitioner along with his clan members wanted to construct a road, and therefore activities were started for construction of such road. Full stop. It is a contention of the petitioner that the land being his own, the complainant, who is not the owner of the land, not the owner of the land, could not have possibly complained about construction of any land. Full stop. In spite of that, the complainant has filed an FIR before Sagali police station. So Sagali police station, contending that his Jhumland along with Jhumland or Orange or
Orange Garden, man, I don't know.
his Orange Garden as well as Orange Garden and Guava Garden had been destroyed by the petitioner and other clan members for construction of the road. Full stop. After receipt of the aforesaid FIR was dated. FIR was
Dated, man.
21/6/2024.
Yes.
On receipt of the FIR dated 21/6/2024, after investigation of the matter, the police has filed the charge sheet on 24/11/2024 under section 447/427/297 of Indian Penal Code against the petitioner. It was like only against the petitioner?
Malad?
Only against the petitioner?
Yes, man, only against the petition.
Against the petitioner. Full stop. The learned counsel appearing for such sheet was filed. And which was the order that was which?
Malad, 19/9/2025.
Page.
Page 67, last page.
On submission of the aforesaid charge sheet, the learned chief judicial magistrate UPIA has taken cognizance of the has issued process by issuing summons, and fixed the matter for evidence on 11/12/2025, vide his order dated 19/9/2025. Being aggrieved by such issuance of summons, issuance of process and summons, the present petitioner has filed its instant petition, instant criminal petition for quashing and setting aside of the order dated 19/9/2025 passed by the learned CJM UPR, full stop. Full stop. The learned counsel, Mr. Tafu, the learned counsel appearing for the petitioner submits that the land in question belonged to his forefathers and though there was a dispute as far as the ownership of the land between amongst the family members and other clan members, the same was settled
Yes.
by a validly organized NIL-wide settlement agreement dated 25/11/2022 in favor of the petitioner. Full stop. He submits that the complainant is neither a party to the settlement agreement, nor he is anyway involved in the matter, but he was illegally cultivating in the aforesaid land belonging to the petitioner. Full stop. Though the petitioner, he further submits that though the complainant was aware of such settlement, arrived at between the parties, he did not stop cultivating in the aforesaid portion of land. Full stop. He further submits that as the petitioner, along with his other clan members, wanted to construct a road there, he had to clear the cultivation what was there on the aforesaid plot of land, which is legally owned by him. Full stop. In view of the aforesaid, he submits that he was neither a trespasser nor he has done any mischief in the instant case, as he has only cleared his own land for the purpose of constructing a road. Therefore, he submits that the charge sheet filed against the accused against him and the issuance of process in the instant case is not as per law, and therefore the same should be set aside and quashed. Full stop. The learned APP, the learned PP, Mr. D. Loy, the learned PP, on the other hand, submits that case diary the TCR, the trial court record in the instant case would be required for consideration for adjudication of the matter, and therefore he submits that in the at this stage interim should not be passed without perusal of the trial court records. Full stop. This court has heard the submissions made by the respective counsel appearing for the parties, as well as gone through the materials brought before this court. It is seen that it is seen from the records of the, it is seen from the application made, it is seen from the petition made by the petitioner that there is a settlement deed, land settlement deed, wherein his name appears. Where in settlement deed, where is your name?
First, madam.
His name.
No, his name doesn't appear, madam.
So whose name is there?
Madam, 90 villages were present, madam.
But your name is not there.
My name is there.
Tabo.
Yes, madam. First, lordship, page 15.
Tabo Tale, na?
Tabatalo. Yes.
Tabo Tale. His name appears in the settlement deed and in a settlement deed at serial number 1. So serial number 1, and it is seen that a settlement has in fact been carried out. A prima facie settlement. This seen prima facie that a settlement has been carried out. Settlement has been done. Settlement has been done between the parties and the petitioner. Petitioner seems to be owner of the disputed plot of land, full stop. Without going much into the merit of the matter, this court is of the considered opinion that this considered opinion that this matter will require further hearing, and therefore it is directed that notice to be issued. Therefore, further adjudication and therefore notice should be issued in the instant case. Full stop. Accordingly, let the notice be issued on respondent number 2 by speed post, full stop. Steps for notice, issue of notice, notice shall be taken by the council appearing for the petitioner within 3 days of passing of this order. Full stop. In the meantime, as an interim measure, the order dated 19/9/2025 passed by the learned CJM UPR is stayed until further consideration of the until further consideration of the matter on receipt of the trial court record by this court. Full stop. It is needless to mention that on receipt of the trial court record, and if trial court record, the further consideration will be made whether to extend the interim order or not. Full stop. Registry to call for the trial court record from the court of Chief Judicial Magistrate UPR.
Yes.
Chief Judicial Magistrate, scan copy of the trial court from the court of the Chief Judicial Magistrate UPR in connection with the Sagali PS case number 11/2024. Sagali PS case number so and so corresponding to GR number 686
Yes, 24.
stroke 24. Let the matter be listed when
After 4.
Hmm?
After 4 weeks.
For safe side,
Notice if to go.
let the matter after 4 weeks.
like
Definitely.
steps upon the private respondents. Madam.
Yeah, private respondent, but he is appearing, so it is that you
No.
can mention Mr. Dispense with.
Madam, Respondent number 2, madam.
Hmm?
Complainant, we have made the complainant as a party.
Yes, respondent number 2.
Yes,
So notice will go to him.
yes, madam.
Respondent number 2.
Yes, much,
Respondent number 1, he is appearing,
Yes,
so
yes.
it's not required.
much of.
Item number 7, it's a password for the timing matter.
Yes, he have got the receipt. How much money paid? He give me details. Your name?
R. Chongruja.
Heard so and so, the learned counsel appearing for the petitioner, also heard the learned APP, the learned APP for the state. This is an application filed under section 528 of BNSS 2023 for quashing and setting aside the FIR number 15/2025 dated 11/2/2025 registered under section 106 in bracket 1 and 281 of BNS at Bandradeva Police Station, Papumpare district. Papumpare district, corresponding to GR case number 119/2025, pending before the learned Chief Judicial Magistrate, UPR, full stop. The instant petition has been filed jointly by petitioner number 1 and 2 for quashing the criminal proceedings in GR case number 111/2025. You that an application, you have written there, you mentioned that it has been filed jointly by the petitioners for, you remove that setting aside of FIR part. You write this setting aside and quashing the proceeding under GR number. The case of the petitioners is that on 11/2/2025, an FIR was lodged before the Bandradua Police Station, Papumpare district by one Sri Nade Chumiang, in bracket petitioner number 2, against the petitioner number 1, alleging that on 10/2/2025 at around 11 p.m. his wife, the complainant's wife, late Bengia Yapiam Nade, met with an accident at Mirzuli Karisingsa Kasingsa
Yes, Lord.
Kasingsa viaduct. What is viaduct? Karsingsa, Karsingsa, wherein she was hit by a motorcycle bearing registration number AR-01T-7785, ridden by the petitioner number 1. Full stop. It was alleged that the wife of the complainant succumbed to her injury and declared brought death in the hospital, that is TRIMS Naharlagun. Full stop. Was there any case registered after that? What was the case? The case
It's GR,
after FIR?
it's GR case number 119 of 25, Your Honor.
On receipt of the FIR, police registered which case? GR case, no?
Yes, Your Lordship.
The police registered, and after the receipt of the FIR, GR case number
119.
119 of 2025 was registered. And after investigation, charge sheet was filed on 11
June.
6/2025 before the Court of Chief Judicial Magistrate, EPR, Arunachal Pradesh. The learned, full stop. The learned counsel appearing for the petitioner submits that during the pendency of the proceedings before the Chief Judicial Magistrate, the complainant, that is the petitioner number 2, and the accused, that is the petitioner number 1, have come to an amicable settlement by way of signing, by way of executing a settlement deed dated
10/6/2025, Your Lordship.
settlement deed dated 10/6/2025, wherein both the parties have agreed to settle the case amicably and not pursue with the case pending before the learned CJM UPR. It is submitted by a learned counsel that in the that in view of the settlement agreement which provided that the petitioner number 1, the petitioner number 2 shall not pursue the case which was lodged before Banderdua police station, and police station against the petitioner number 1, and the petitioner number 2 shall not blame the family of the petitioner number 1 for loss of his wife. Full stop. She further submits that in terms of the agreement, in terms of the settlement agreement, aforesaid settlement agreement, a compensation amounting to rupees 8 lakhs was paid by the petitioner number 1 to petitioner number 1 to petitioner number 2. Full stop. To that effect, the learned counsel appearing for the petitioner has submitted a Xerox copy of money receipt issued by the respondent number, issued by the petitioner number 2. Full stop. The petitioner number 2 dated 10/6/2025. A copy of the same has been submitted before this court, and the same is marked as X for the purpose of identification and kept on record. The learned counsel submits that in view of the aforesaid settlement arrived at between the parties, the criminal proceeding pending before the court of the learned CJM UPR would be should be quashed as the same will not same will not same will be same as the same will be a futile exercise and wastage of judicial time. She submits that since the complainant has agreed not to pursue with the proceeding, the conviction of the petitioner shall be conviction of the petitioner. The likelihood of conviction of the petitioner is also not there. In view of the aforesaid, she submits that the instant petition, in view of the aforesaid, since the petition has been jointly filed by the accused and the complainant, being petitioner number 1 and 2, the same should be allowed by quashing the proceeding pending before the learned CGM UPA. Full stop. MSL Hage, the learned APP appearing for the state, submits that in view of the settlement agreement, if the instant petition is allowed by quashing the proceeding pending before the CGM UPA, she doesn't have any objection to that. Full stop.
Lordship, as they are already settled mutually and already compensated, Lordship.
Yes, is that, I mean, that is already, I mean, because in view of settlement and the compensation has been done.
Lordship, and the similar matter already was, Lordship, by the Lordship.
The learned counsel appearing for the petitioner has also submitted a copy of the case.
Case number, criminal petition 9/2024, Lordship.
Copy of the case of Ojing Darin and 2 others versus State of Arunachal Pradesh in bracket criminal petition number 9/2024 decided by this court on 12/2/2025. She submits that in similar circumstances of an accidental death, comma, on coming to terms of the terms of a settlement agreement as well as payment of compensation to the victim's family. This court has already quashed the proceeding involved in the case which was pending before the trial court. Full stop. This court has heard the submissions made by the respective counsels as well as gone through the materials brought on record. Full stop. Having perused the judgment dated 12/2/2025, passed in the aforesaid case of Ojing Darin in bracket Supra. This court is also of the considered opinion that in view of the settlement arrived at between the accused and the complainant, as well as taking into account of the fact that a suitable compensation has already been paid to the complainant in bracket victim's husband. This court is of the considered opinion that the instant case should be also allowed by quashing the proceeding pending before the learned CGM UPA in connection with GR case number
119 of 25.
25, 109, 25, full stop. In this connection, yesterday also I have dictated like this, some case laws are there that will include and like pass the order. That I'll give it to you. That is already there. You can take it from there. That will allow this. I'll just put in some case laws, which are, yesterday only I have dictated, so I don't want to repeat it again here. So that is there, we'll put it. Okay,
Yes.
we'll allow this. So accordingly, this petition will be disposed of.
Ajam, let's start.
A
Item number 12.
similar case I have dictated yesterday only, so that part will cover that.
Item number 12.
May I please, Your Lordship? Your Lordship, this is a bail application, Your Lordship.
Hmm.
Your Lordship, the accused person was arrested for offense under section 21B, 27A, and 29 of NDPS Act.
Hmm.
However, Your Lordship, during the framing of charges, two sections, namely section 27A and 29, have been dropped. Now only against 21B is standing against the accused person. Your Lordship, so far, Your Lordship, he was arrested on 7/4/2025. So far, he has spent 8 months, 8 days in judicial custody. Your Lordship, as for the FIR, the total item that has been alleged to be seized from the accused possession is 44.36 gram. Your Lordship, but the
4.36 gram.
gram,
44.
44 intermediate quantity. Your Lordship, but
It's in the higher side of intermediate quantity.
no, it is in lower, Your Lordship.
Hmm.
Intermediate is till 100.
250 grams, no? What is the commercial quantity here? Heroin, isn't it? Huh?
Yeah, right.
Heroin is how much? Heroin is
Your Lordship, what
250 gram, probably, no?
250.
50 gram. Hmm?
Two 50 gram, Lordship.
250 gram, no? That's what I was saying.
But Your Lordship, judicial record.
Hmm.
Your Lordship, may kindly come to page number 38.
Hmm.
38, when all the siege items were produced before the judicial magistrate first class UPR for weighing,
Hmm.
it was found 7.4 gram.
But maybe without those whales,
Yes, Your Lordship,
with whales maybe 44 grams.
44.
Without whales probably 7 grams.
Yes, Your Lordship.
Yes.
Therefore, Your Lordship, charge sheet has been filed under for intermediate.
But otherwise also intermediate quantity
Yes,
44.
Your Lordship, it is
No, got it,
What?
got it. So it's without whales, it's 7 point some gram. Yes.
it is
Then
slightly higher above the small ground.
Hmm.
Small ground is 5 gram and it is bare level in nature. So Your Lordship, it's making the bail as a rule, jail as an exception. So on that ground, Your Lordship, I have filed. And secondly, Your Lordship, the accused person was arrested only on suspicious of hiding the siege item in the bathroom of civil secretariat building.
Hmm. So you are in bail for you were in jail for how many days?
8 months, 8 days.
8 months, 8
8
days.
days.
Without bail from the date when you were being arrested.
Yes, Your Lordship.
Hmm.
Your Lordship, may kindly come
What are the other grounds you are taking?
non-communication of the ground of arrest.
Hmm.
Your
Where,
Lordship,
where
he
where
has
is
been
that?
arrested in complete violation of the guideline laid down by the Supreme Court.
No, where is your arrest memo or section 47 and 48 notice?
Your Lordship, page number 82.
So that is one ground, and second ground,
Second ground, Your Lordship, he has been arrested.
no, notice to you, where is the notice?
Notice page number 72.
72.
Yes.
The notice to a family, section 51.
51, not sir, Your Lordship.
Hmm?
Not sir. Your Lordship, the family of the accused person was informed lately, very lately about his arrest.
You're right. Your name?
M. Kamcham.
You have anything to say?
Yes, Lordship, mere procedural lapses cannot be, Lordship, Lordship is aware of the state of Karnataka versus
I know.
Darshan, Lordship. Your Lordship, followed after the Darshan case, Supreme Court has made very clear that the ground of arrest has to be given in writing.
Take down, take down, take
But
down.
the-
Heard, mister? Your name? Your name, please.
M. Kamcham.
The learned counsel appearing for the accused applicant also heard Mr. D. Loy, the learned PP for the state. This is an application under section 483 of BNSS praying for release of the accused person in connection with Itanagar PS case number 55/2025 under section 21 in bracket small b stroke 27 in bracket A stroke 29 of NDPS Act. The gist of the case, as has been narrated in the FIR dated 7/4/2025, 25 is that on receipt of certain confidential telephonic information, the police team went to, you are Vicky Chatri.
Vicky Chatri.
Police team went to the room wherein the accused applicant was staying. Full stop. On reaching the spot or on reaching the room, the police team searched the room and from the bathroom of
Your Lordship,
Huh?
the arrest made was in a civil secretariat office. Recovery was made from office
office bathroom.
bathroom. bathroom.
I'll mention that. Went to the room, but there is a room here allotted to you.
No, not allotted. The staff force, after finding the contravention weapon hidden in the bathroom, on suspicious, I was forcibly taken into the bathroom and locked until the police arrived. This is the Your Lordship case.
Where is the FIR?
Page number 85.
Hmm?
85.
What was written? What was written? Huh? Yes. Always last time. No. On receipt of the confidential telephonic call, na? The other line. No, police went to the no, don't write room. Police went to police went to the 1 second. I'll tell you. Police went to the office of the police went to the civil secretariat building. Civil secretariat building, Itanagar. Full stop. it was alleged that an information was received from the secretariat that that the accused person came to the secretariat for selling of certain narcotic drugs, and on suspicion and getting some information, and on suspicion, the accused person was in fact confined in the bathroom of the secretariat till the police team reached there. The police team reached there. The police recovered a search was made by the police, and during the process of search,
For further questioning, Lordship.
one second. On search of the bathroom and the person, the police did not recover anything from the bathroom as well as the person. However, on questioning, some amount was, from your body.
Your Lordship, kindly.
One second, following the depositable presence of the incident, a personal search was conducted. During the process of personal search, the accused of the pockets of the part of being so, something was received from you.
Your Lordship, kindly come to the statement of the witnesses.
No, that is a
They are
different
very
thing. We are not talking about a statement of witnesses, Mr.
Yes.
We are talking about the allegations which has been there. We are not, we are not in a trial. I'm just, we want to see what are the allegations. Correct. You write on search of the body, though nothing was recovered from the bathroom, but on search of the body of the accused person, 8 plastic vials containing suspected heroin was found. On inquiry and on further investigation and questioning, the police recovered 18 more plastic vials from behind, hidden behind the bathroom window. Full stop. The police seized those banned narcotic substances, and the accused applicant was arrested on the same date, that is on
8/4/2025.
8/4/2025. 2025, and since then the accused applicant is behind the bars for last more than 8 months and 8 days. Full stop. Next para. On receipt of the FIR, the police filed which case number? NDPS case number?
NDPS case number 56 oblique.
The police registered
Sultanagar PS case number 55/2000.
25 under the aforementioned sections of NDPS Act. Full stop. After completion of the investigation, the police filed the charge sheet dated where is the charge sheet?
Charge sheet page number 22.
You don't write anything in the this thing and the petition.
Your Lordship.
Where have you written about charge sheet? Nothing has been written.
Charge sheet, para 5.
Para 5. Where?
Para 5. With the applicants beg to submit that the investigation in the instant case is complete. The investigation officer has
Where para?
para 5, page number 4.
After completion of the investigation, the police filed a charge sheet number 175/2025 Under which sections?
Under sections. Under section, under all the section, your lordship.
Okay, as file, uh, uh, date is not there. When?
5.74.
Why did you write all these things in the petition? The charge sheet number so and so you have written, but no date. This should, I mean, you should mention all these things. I mean, always date should be there. When charge sheet number is what, date is what, then only all the facts comes. And the court, I mean, court also, it becomes convenience to pass the order. If you do not write all these things, every time we'll have to again go there, refer their pages, takes time, no?
Yes, yes.
So you should always write all those things. Right? This is the way to draft petitions.
Yes.
So you always write dates, I mean, charge sheet, FIR, whatever, dates always should be mentioned, number. Charge sheet was filed on
5/25/6/2025.
25/6/2025. Thereafter charge was framed.
Thereafter.
So when?
The charge was framed on
Thereafter charge was framed on
13/8/2025, lordship, at page number 17, lordship.
13/1, page number
17,
17.
and excerpt to lordship.
Okay. Charge was framed under, thereafter, charge under section 21B of NDPS was framed against the accused applicant by order dated 13/8/2025 of the special judge NDPS UPR. Full stop. Full stop. The learned counsel appearing for the accused applicant submits that the accused applicant is nowhere linked with any such activities of selling or smuggling or selling or smuggling, selling, purchasing, selling and peddling of narcotics, drugs. Full stop. He submits that the accused applicant was detained in the bathroom and thereafter arrested by the police official on mere suspicion, and mere suspicion. Full stop. He submits that he was nowhere linked of hiding anything in the bathroom, and only on suspicion he has been arrested. Full stop. He further submits that since the police has already completed the investigation, charge sheet has been filed, investigation, charge sheet has been filed, and charges have been framed. His further custodial detention may not be required in the instant case, since he has already spent more than 8 months and 8 days behind the bars. Full stop. Next paragraph. The learned counsel appearing for the petition accused applicant further submits that there is a violation of the mandates of the BNSS while arresting the accused applicant, as the accused applicant was not properly served with the arrest memo as well as notice under section 50 of the BNSS Act. He submits that while issuing the notice under section 50 of the BNSS Act, no grounds have been mentioned in the aforesaid notice. He further submits that in the arrest memo also, which page?
Page 82.
Hmm?
Page 82.
Arrest memo also, no grounds of arrest have been mentioned. Your signature is there in the arrest memo?
There is no,
Hmm?
yes,
Where?
on the bottom, left side bottom.
Okay. Full stop. In view of the violation of section 50, section 50 of BNSS, he submits that he submits that the whole process of illegal is and the whole process of arrest of the accused applicant is illegal, and his personal liberty his personal liberty, which is his fundamental right under Article 21 and 22(1) of the Constitution of India being violated, he should be allowed he should be immediately allowed to go on bail. Full stop. In this connection, he has referred to the case of Mihir Rajesh Shah versus State of Maharashtra, reported in 2025 Supreme (online) SC 9939 of the Honorable Apex Court, wherein the Honorable Apex Court has specifically held that grounds of notice to be given, grounds of notice under section 50 of BNSS to be given to the accused applicant immediately after his arrest and not later than 2 hours before production of the accused applicant before the magistrate. Full stop. He submits that in the instant case, since no proper notice under section 50 of BNSS has been given, providing the grounds of arrest to him, while he was arrested, the arrest becomes illegal in view of the ratio laid down by the Honorable Supreme Court in the aforesaid case of Mihir Shah Supra, as well as the statutory mandates under section 50 of BNSS Act BNSS 2023. Stop. The learned, on the other hand, the learned, next line you write, in view of the aforesaid, the learned counsel submits that since he has already spent more than 8 months and 8 days, and the quantity which has been recovered from him, alleged to have been recovered from him, is of intermediate quantity, weighing how much?
Weighing, as per the judicial record, it is 7 point,
Weighing 7.4
gram.
7.4 gram, which is in the side of which is at the lesser side of intermediate quantity, comma quantity. He should be allowed to go on bail at this stage. On the other hand, the Mr. D. Loy, the learned public prosecutor submits that case diary has been received.
TCR, Lordship.
No, TCR has been received, and there are materials which are there are incriminating materials which from points finger to the guilt of the accused applicant, and therefore at this stage the petition, the accused applicant should not be granted bail, right?
Yes.
That's what a submission.
Lordship,
He
as per,
further
as,
said
as per my humble understanding, Lordship, this Mihir Rajesh Shah will be effect from the 6th of November, Lordship. As per paragraph, Lordship, so she already submitted before the Lordship. Paragraph 58.
That this way I've been dealing with this. I know about this.
Yes.
But Mihir So, but there are other judgments also, Probir Purkayastha,
Yes.
then, Brihan Kumar,
Lordship.
all these things are there, all these cases are there. So he'll have to give, there is no escape from there, grounds of arrest.
Yes.
Mm. Mm. So that's your submission, more or less. You are opposing this. This court has gone through the materials brought before this court, as well as the TCR that has been received from the trial court, from the court of special judge, where
Yeah.
special judge UPR, special judge bracket NDPS UPR, UPR. From the bare perusal of the notice under section 50 of VNSS, it is seen that no grounds of arrest have been provided to the accused applicant at the time of arrest, which is in non-compliance of the mandates of section 50 of BNSS 2023. Full stop. This court has also observed that the quantity that has been received is of
7.4 grams.
7.4 grams of heroin, which is of intermediate quantity. Therefore, the rigors of section 37 of the NDPS Act shall not be applicable in the instant case. Full stop. This court has also noticed that the accused applicant has been arrested on 8/4/2025, and he is behind the bars for last 8 months and 8 days. Full stop. Taking consideration of the ratio laid down by the Honorable Apex Court in the case of Brihan Kumar, I'll give you a citation. Brihan Kumar, just write Brihan Kumar, and Probir Purkayastha. I'll give you the citation. Probir Purkayastha, as well as the recent judicial pronouncement of the Honorable Supreme Court in the case of Mihirsa Supra. This court is prima facie convinced that the mandates of the principles laid down in the aforesaid cases by the Honorable Apex Court has not been adhered to by the arresting authority while arresting the accused applicant in connection with the Itanagar PS case now 55/2025. Full stop. After taking into account the whole matters in entirety, and on consideration of the fact that section 37 of the rigors of section 37 of the NDPS Act shall not be applicable in the instant case, this court is of the considered view that the accused applicant should be released on bail at this stage. Full stop. Accordingly, it is directed that the accused applicant shall be released forthwith on furnishing of bail bond of rupees 50,000 with a surety of like nature to the satisfaction of the Court of Special Judge NDPS UPR, subject to the following conditions. Number one, that the accused applicant shall cooperate with the investigation and make himself available as and when he is required to be present before the trial court. Will cooperate with the not investigation, is cooperate with the proceedings of the trial court. And appear before this. And the accused applicant shall not try to influence or intimidate any witness or evidence involved in the instant trial. Full stop. And then you write the accused applicant shall submit all his identification documents such as the Aadhaar card, then voter card, Aadhaar card, voter card, PAN card, etc. Before the court of special judge UPR, if the same are not yet surrendered. Then you write
Lordship, one regular government employee.
Your
Lordship, this condition is not practicable because in many cases, government employee was given as a security. Achievement is not possible, Your Lordship.
why?
Because Your Lordship, here in the case, the very few less member are government employee and they are not ready to stand as a security. It will be amount to denial of bail, Your Lordship.
Okay, I mean these points only.
Since he is even he is not rented house at Itanagar, Lordship. Your Lordship, I am a government employee of
You are not
horticulture.
government employee. What you are doing?
Contingental.
Hmm?
Contingent.
Contingent.
Your Lordship, I have been working for last 10 years and my seniority, Your Lordship, there is no possibility that I will evade the jurisdiction of this honorable court.
Then put another condition that that the accused applicant shall not leave the jurisdiction of the learned special judge NDPS without prior permission from the aforesaid court.
Your Lordship, my humble submission is that he is from very
No, that you are an NDPS accused, brother. So I mean you will not leave without permission.
Your Lordship, the surety amount maybe Your Lordship reduced because Your Lordship he is from very he's fine.
Okay, make it 30,000.
Yes.
But you will not leave without jurisdiction, without prior permission. Okay.
Yes.
Till the trial is completed.
Much obliged.
Item number 13.
Lordship, we have taken steps upon the respondent number 2 and 3, in fact, the victim and as well as the informant. And LCR was also called for in this matter.
Lordship,
But it hasn't been received, I see. No, LCR not I'm talking about. I'm talking about this steps.
victim, Lordship.
Huh?
Victim, Lordship, if you are before office of the PP, Lordship, this afternoon, Lordship, in the lunch break, Lordship, he visited my office, Lordship. She visited along with her mother, Lordship. Lordship, they are unable to provide private counsel, so they are unable to engage a private.
And then we'll engage some amicus
Yes,
curiae.
Lordship, LSC, Lordship. LSC may be appointed, Lordship.
This is a POXO matter, no?
Yes,
Lordship.
Lordship.
Heard Mr. J. Gini, the learned counsel, appearing for the applicant. Applicant also heard Mr. D. Lowy, the learned public prosecutor for the state. This is an application under section 483 of BNSS 2023, praying for release of the accused on bail in connection with Itanagar Omen police case number 07/2025 under section 75 in bracket 2 of BNS 223, read with section 10 of the POXO Act. The learned PP submits that on receipt of the notice by the respondent numbers 2 and 3, they have approached his office today, that is on 12
Yes,
2025, and express their inability to engage a counsel to represent them in the instant case. instant case. In view of the aforesaid, the learned PP, has prayed that an amicus curiae.
Lordship, as per notification 17, it's LAC, Lordship.
Huh?
LAC, Lordship, Legal Aid Council, Lordship. As per notification,
LSC,
17, Lordship.
no, amicus is not there.
No, Lordship.
Um,
In
Huh?
in column 13, in column 30, oh, sorry, so close 3, Lordship. Close 3, part 2, Lordship. It's a LAC, Legal Aid Council.
Legal Aid Council.
Yes.
He submits that, he prays that a legal aid council, as named, a legal aid council from the list of legal aid councils, available before the,
Lordship, it's before,
but legal aid council, you have a
Lordship, we have a
High-
list of Legal Aid Council, Lordship.
list of the legal aid councils, full stop. Accordingly, you have a list. Whom to appoint? You can suggest any name.
Lordship, J. Doji,
J. Doji, okay, J. Doji's name.
O. Binga.
J. Not Doji's name is there. Will appoint accordingly. J. Doji, that book, J. Doji, is
Either or Binga or Binga.
is appointed. G. Doji, the Legal Aid Council, is appointed. The Legal Aid Council is appointed to appear on behalf of respondent number 2 and 3. Full stop. Scan copies of the TCR as received may be retained. Let the matter be fixed when.
Lordship, can it be on 18, Lordship?
Hmm?
18 of this month.
Let the matter be fixed on 18th.
Lordship, one small correction has to be done in course title, Lordship.
They file an IA.
Lordship.
File an IA immediately if there is correction. Otherwise, it will be delayed. Immediately you file and correct it.
Item number 16. It's a bail hearing.
My lord, on last occasion, CD was called for now. CD was called for now.
Keep it with you. So, I mean, what was, section 47?
Yeah, 48,
47, 47 and
47 and 48.
47 and 48. You have flag marked it? 47 and 48?
Yes, my lord, this one is.
Now, whether you have flag marked it,
Arrest memo and letter intimation.
47 and 48.
Yes.
One is for 47 is notice to the arrestee, and other one is to the relative.
Yes, my lord.
Those you have, those are there. Have you seen it?
My lord, there is one letter intimation, my lord, that is to the arrestee, my lord.
Have you seen those contents? Grounds are there.
Grounds are there, my lord. Though.
No, what is your submission then?
My lord, grounds, my lord, though it is not specific, but generic grounds here, my lord.
Give it to me, sir.
Page number 121, my lord.
Page 121.
121, my lord.
And this thing, section 50 notice, where?
There is, my lord, phase. Well, page number 124, my lord. That one, arrest intimation, my lord. Arrest intimation.
Page 120?
24 121, my lord. 24 or 121. 121 or 124.
Okay, arrest intimation.
Yes, my lord. Here in the column 3, this offense is given, my lord. Alleged offense is given under section 3082 BNS, case number 7725, and 4 is ground of arrest.
Yeah, ground of arrest is not ground of arrest. You are being arrested for your alleged involvement in the commission of and above mentioned offenses. Which offenses? Above mentioned offenses as per information and investigation is not ground of arrest. And there is no notice, one notice only 4748.
Yes.
And I mean, that information has been given to her where? Name and contact person informed.
This one is wife of the accused person, my lord.
It has to be written notice as per Supreme Court's judgment. It has to be a written notice duly received by the family member, wife, nominated person, friend, any of them, relative. I mean, this kind of notice, I mean, then you tell your police officers, all the cases they'll be getting bail. This has to be changed.
Well, this notice is served to the
Mr. PP,
yes,
a
ma'am.
notice has to go, a written notice.
Yes, my lord.
I mean, Bihan Kumar case is very specifically stated. The written notice has to go, and written notice has to be given to the family member.
My lord.
And that has to be properly accepted, duly accepted by them. I mean, here nothing has been given. Where? Thumb impression of the accused, no signature from this thing, family member. So we'll have to allow him to go on bail.
My lord.
This was the case of what?
Lordship, extortion. Extortion case.
Extortion.
Extortion.
How much money?
Lordship, as per as allegation 5 crore. As per as allegation.
That's why you are a very rich lawyer.
Lordship, no. For this case, it's pro bono. Because my just younger ones relative, I'm doing it for pro bono, not for rich.
I'm just pulling your leg. I mean, had it been like this, then all the lawyers would have been, I mean, filthy rich.
Yes, Lordship.
So this is there are violations.
Madam.
And how many days you were behind the bars?
Lordship, 87 days still.
87 days.
Yes, Lordship.
Okay, I'll pass an order.
Yes,
Madam.
okay.
Bail will be granted to you.
Obliged.
Item number 14.
Lordship, may I make in item number 13, Lordship, in appointment of LAC, Lordship, she is also the member of CWC. In fact, she is the chairperson. And there is a report from the CWC. It's part of the record, Lordship. There might be some.
Some Doji?
Yes, Lordship.
Then change the name, somebody
Yes,
else.
He is also one of the Lordship.
Mr. Ubori, na? Mr. Ubori, yeah, in place of Doji, maybe Ubori.
Obliged. My lord, I'm for the sole respondent.
And for the petitioner.
My lord, on the last occasion, we filed the Bakalatnama.
You want some time
Yes, my lord.
on the prayer of the council appearing for the respondent. Let the matter be listed on.
My
When?
lord, after 4 weeks.
Why after 4 weeks? So why so much time is required?
Property.
No, on 8th of January.
Your Lordship, there is an interim that may be continued.
8th of January. 8th of January, right? 8th of January. You are Mr.
D. Pangu.
So and so, praise for so and so. Prayer is not objected to, right? And prayer is not objected by MS so and so, the learned counsel appearing for the petitioner. Then you write interim order so passed earlier, shall continue till the next.
Item number 15.
What file?
Lordship, this is today's order column, Lordship. Here, Lordship, TCR yet to receive.
Case diary?
TCR, Lordship, trial court record yet to receive, Lordship.
Yet to receive,
Yes.
but no one is appearing.
Lordship, they are not appearing also.
So we'll just none appeared for the petitioner when the matter was called for. For the interest of justice, let the matter be listed on 19.
Lordship,
19.
reminder maybe.
But this week, I think the 20th is also court is open.
20. Lordship, 20. Yes, Lordship.
20 also this Saturday your court is open
Yes,
because
Lordship.
15th is
Yes,
closed.
Lordship.
No?
Yes, Lordship.
So we'll fix it on 20th then.
Lordship.
Let the matter be fixed on 20th.
Yes, Lordship, reminder may be sent to.
But I don't know whether notification has come or not.
Oh, yes, Lordship.
We'll put it on 19, but I think yesterday there's some decision has been taken to keep it open on 20th. Saturday. 19 will fix it.
Then,
MS Hagi, APP is present and she submits that TCR in the instant matter is yet to be received. Registered to issue a fresh reminder for requisition for calling fresh reminder calling for the TCR from which court?
Lordship, from the session, Lordship, UPL, Lordship.
Huh?
From the special court, UPL.
From the special court,
POCSO, UPL, Lordship.
POCSO, UPL.
Much obliged, Lordship.
Item number 10.
But it's POCSO, then respondent if somebody is appearing.
Lordship, actually, Lordship, the service is Lordship completed upon the Lordship victim, Lordship. Now, LSC may appointed, Lordship.
No one is appointed.
Till now, no one is appointed.
Let us wait for some time.
Yes,
They may engage someone.
Yes, Lordship. Obliged.
You are appearing or what in this matter?
For item number 10.
Number 10.
Yes, 10 years.
Lordship, the matter may be fixed after 3 weeks. The conducting counsel is out of station.
Okay. Who is conducting counsel?
El Perme.
Okay. MS so and so, the learned counsel appearing for Mr. L. Pame, the leading counsel in the instant case, prays that the matter should be listed after 3 weeks as Mr. L. Pame is not in town. Not in town. Let the matter be listed. Let the matter be listed on 8th of January.
Okay.
8th of January.
Item number 11.
May Lordship, I'm for the petitioner Lordship. Here, this is a joint petition filed under section 520 of the BNSS Lordship. And this is a joint petition Lordships.
What is the offenses?
Offense is cruelty and assault.
Husband and wife?
For years.
Husband and wife?
Yes, your Lordship.
So you have agreed. Where is the settlement?
Settlement was done on the Lordship.
Okay,
20
page 53.
Page 53 to 55 Lordships.
Okay.
Now, petition number 2 wants to put an in this criminal proceedings pending. petitioner number 2, who is the wife lordships in this case, wants to put in this.
This is the number 2 is the wife and
Yes.
this is husband.
Yes, lordships.
Okay, so both have jointly filed.
Yes, lordships. Now decided to leave.
So why
peaceful-
it is in Arunachal Pradesh so much of joint petitions?
Lordships.
I mean, husband and wife quarrel, then they file a case, and after some time they patch up and come to the court. Huh? Very impulsive.
Lordship.
Huh?
Yes.
I don't know. So many cases I can see here. Huh?
Yes, exactly.
Actually, I have
since-
been taking criminal bans in Guwahati High Court also, but like Guwahati very less this kind of petition. But Arunachal, whenever I came, first time after my elevation when I came, 2 weeks I sat there. I think there are 4 or 5 petitions. This time also so many petitions. Anyways, we'll allow this.
Yes, it can be.
I'll pass the order.
Okay. Because
You
there
write,
is-
write their names. Huh? Write their names. Yes.
there's a practice of polygamy in the state since time immemorial. That's why something is still left to be exercised.
Maybe. It is arrangement. So I'll pass the order.
Oblige.
Oblige.
So have a great weekend ahead.
Thank you, sir.
Thank
Thank-